may I mention one case number?
Wait for the judgments.
For judgment,
Wait for
item
the
1,
judgments.
2nd Appeal 2 of 16.
Your Honor, the humble request is to kindly
Could you hear what I said?
Yes, Your Honor.
Wait for the judgment.
Your Honor, this is important because this will, if the judgment is pronounced in the
Yes.
particular case,
Which case?
this particular case,
This is
Sarla
second
Bhai
appeal
Golai,
2.
Sarla Bhai,
I don't know the name. SA2.
yes, Your Lordship.
What's there?
Your Lordship, my client has been misrepresented. She is the client. She has been misrepresented and she has not been given a fair chance to present her.
I don't know. We are pronouncing the judgment. You do whatever you have.
Your Lordship, a humble request, it will be a miscarriage of justice.
We don't bother about it.
There is a necessity,
All
the
the
necessary
substantive
parties are
questions.
not involved, Your Lordship.
You
Please,
just stop.
yes, Your
Correct.
Lordship. I go down to you.
All the substantial questions of law have been answered against the appellants and in favor of respondent number 1. However, on account of death of defendant number 1, mother, the distribution of properties would be to the extent of 1/6 share, as the surviving co-sharers are only 6 now. This appeal is accordingly disposed of. The order will be uploaded within 1 hour till next.
Much obliged, Your Lordship.
Item 2, 2nd Appeal 219 of 2022.
All the substantial questions of law, except substantial question of law number 1 within bracket 3. I think there is some error over here. इसको जरा check करना होगा. पूरा print नहीं दिया इसलिए. This appeal is hereby dismissed. I just verify it. ये 1 within bracket 3 क्यों है? Could be a typographical error. However, this appeal is dismissed.
For final disclosure, item 3, 1st Appeal 15 of 2025.
ये किसका था ये वाला ऑर्डर सेकंड वाला 219 में हम ऊपर जी को बोलिएगा एक बार लंच टाइम में आपको दिखाता डेटेड कर लेंगे वो इसके बाद शाम तक आपको यस वी आर हियर
Lordship, the service is complete. I have checked the file. And in fact, Lordship had indicated way back on 27th of March itself
यस
for listing this matter for final disposal. But in the meantime, what had happened that one of the respondents was not added, who had already expired.
That's right.
So that Lordship has taken, they had moved an application under Order 10 Rule 1.
इट इज पेंडिंग
No, it is pending. Lordship has decided
टेल अस
that.
व्हाट यू वांट टू डू
Lordship, I am for hearing and disposal. Lordship has even heard it on the
No
broader
problem.
aspects of it, and issue is very narrow.
इट इज फॉर्मली एडमिटेड
Yes.
It has been.
सो
It has been admitted.
इट्स स्टार्ट
Next Monday, check will take it.
यू डोंट इन्फॉर्म द अदर साइड जस्ट
The problem is only on the
Notice,
last date. Lordship
notice
wanted.
is complete
It is complete.
Last
It is
date,
complete.
notices were directed to be served and
We have
now
checked
we
the
both
SR
will-
of RF
31 A to E, where Lordship directed them to serve through.
that's right. How about F?
F has been served through speed post. Tracking report is there.
Okay.
Tracking report is
Then
on.
I
We both the
will
parties.
formally record service of notice.
Yes, Lordship, because
Right.
both the
Service is
council have
complete.
checked before. We have checked it from record.
And then you tell us when you want. You want to prepare some notes.
I'll prepare.
You see, the best
Because
way.
it was for service of notice.
No
I'm
problem.
not seeking
No problem.
a large
Mr.
time or
Rahul,
something.
no problem about
Yes.
it. But what I want is that these first appeals at times involve very intricate question of fact and law. So I just want both of you to prepare some kind of outline of your respective cases. And then I will hear you on those outlines and verify the records, etc. And if required, you can always give us a revised written
Yes,
submissions
absolutely,
and
absolutely.
some judgments, some point of law.
Lordship, I am prepared with that. Written notes is there, judgments are there. For the court, for the other side, and for
You give it to them
I'll give it to them.
if you have no other issues. In any
Because the entire
Mr. Rahul? Mr. Rahul?
Yes.
This, you kindly accept this. You also do the needful.
I'll prepare and
How much time do you need?
And if this is for the court.
Yes, yes, I provide.
10 days or not.
What if the if Lordship could have it on next Monday, because
Because they will also. need to
I am just waiting for this matter to end so that I can enjoy my vacation. I'm not going anywhere. Despite the
Rahul, you
fact that
listen.
the entire June is with us. That is the problem I'm facing.
Mr. Gupta, it's a human right issue. He wants to
Next.
go for vacation. If it is possible for you to commence your hearing on next Monday, you just let us know.
This is what he also
I
requested.
can, but your lordship would be better there on 23rd if your lordship. In the meantime, I'll submit whatever.
I'll be neither here nor there. So this is only one issue is there.
We can do one thing, Mr. You have to file a written submission, that's okay. He has submitted whatever he has. You can just start. And by the time simultaneously you can go on with
Yes.
that. Because I think it will take at least one day I will not conclude. On first day I will not conclude, I will conclude it on the next. Because once I hear the arguments, my method is like this.
But what I say, Lordship, suggests that if Lordship hears on any day,
Yes.
1 hour is sufficient for this matter.
But it is
But
not
I leave it to
sufficient
the
for
court.
me.
Yes, yes.
Right?
But
I'll
the
take
issue
my
is
own
very
time.
narrow, and even in their appeal they have raised only 2 issues. Both issues are squarely covered by the judgments, by all the things I have mentioned there. And it is their appeal. They must
Whatever
come forward.
grounds
now.
they are taken in first appeal, absolutely, we cannot
There is
say
no
that I
problem
cannot argue
about
anything
it.
else.
There is no problem about it. But I take my own time to understand this. A slow coding.
That Lordship is humble.
So, one day I will hear it, and I will post it on the next day, and then in the meantime I'll also do some
No issue.
homework.
That, if Lordship may start on Monday, this is what
You can start on Monday.
Yes, I can start.
You can start
But
on
if your lordship postpones it, then
No,
his
Monday and
petition
Tuesday.
is otherwise
No,
also.
Monday and Tuesday. These
Yes,
two
yes.
days. In
I'll keep
continuous.
it 2 days.
There is no question of any adjournment. It is just Monday and Tuesday,
Yes.
and I will be seeking adjournment.
I'll start on Monday.
That will be the
I'll try to
fairest thing,
finish it
Doctor.
off on the same day.
Because what is happening is that once we hear the matter, and we just, in case it is CAB, and if we are not recording the preliminary submissions by both the parties, later on it becomes
I can
quite a
understand.
burden.
I can understand.
So I will be recording your respective submissions also, and then fix a
Yes.
date in the order itself. There is no problem.
No issue.
On Monday itself.
Monday Lordship may commence. As far as the service
If
part,
in-
Lordship may record.
FA number 15 of 2025, the counsel for the parties are present. They have jointly submitted that the service of notice is complete. They further submit that the matter may be posted for final hearing on next Monday. It is likely that the matter would continue from on Tuesday as well. When do you want to start at 2:15?
So should be ahead. We'll start at 10:30, no issue on that. Whatever time Lordship, otherwise if Lordship may fix any time.
Or 2:15, your lordship.
2:15 would be
No
better.
issue.
Because
That gives me
10:30
a better, I don't have to rise at 4 o'clock to start from Delhi.
Okay.
2:15.
Post for final disposal at 2:15.
Matra.
Records आगे.
जी. Records are there.
इनका क्या नाम है? अंजलि. Where is Anjali? You look at this file. This written submissions is also there.
And
You
Lordship,
have
I can even this Mullah, which will be very
We have
relevant.
that.
It's the latest edition. I have
भाई,
taken
लोग
all the
मंगाइए.
extract.
अब हमें वकीलों से बुक बोरो करना होगा.
It's not, it's only assistance.
May I just take it? I keep it.
Yes, yes. That will be a gesture on my part.
Anjali, you may leave. Take this file. Go through it. I want your inputs. Next Monday.
And Lordship, I think we have the provisions of having the entire file in this computer also, the soft copy. We have the liberty to take in the pen drive because the files are there.
You can have. अच्छा एक बात बताइए.
Because I
जो
just
हम लोग के पास LCR आया हुआ है, उसका सॉफ्ट कॉपी क्या इस कंप्यूटर में अवेलेबल रहता है? ऐसा
नहीं है.
He says that it is there, or I'm not sure.
I think the copy of LCR is there.
LCR is
Soft
where?
copies.
Soft
LCR soft
Soft
copy.
copy.
I can just give 5 minutes and check this.
You just check.
If
Okay.
स्कैन जो होता है तो कैसे हम लोग पास नहीं होता वो स्कैन तो पूरा फाइनल करके
तो स्कैन तो लिटिगेंट के लिए है ना भाई, थोड़ा उपाय लगाइए। स्कैन किस लिए है? लिटिगेंट के लिए।
तो डायरेक्शन जैसे सेक्शन हो तो वहाँ से लेकर वो सेक्शन पर
अच्छा, डायरेक्शन करना होगा जुडिशियल साइन में, वैसे भी हो सकता है।
that's what we are doing in Delhi High Court, that both the sides, the computer are there. If anybody is missing any PDF number and all that, can simultaneously
यहाँ
see
पर
the
हमेशा वो
computer.
एसेस करता
यहाँ पे एनी टाइम
है एनी टाइम
एलसीआर भी
एलसीआर
Yes, this is what I'm
आज
saying.
जिसमें है
And,
ना अगर ये कल भी देखना चाहेंगे तो आज का डेट देकर के वो आज डेट लगेगा
and we are at liberty to take in the pen drive. That liberty I don't know whether we have here or not.
Here it is not there, but
You see, अभी तक हम लोगों ने ऐसा नहीं किया है। जब तक हम लोगों का चीफ साहब
I
का
can
आदेश नहीं होगा, तो आप एक रिप्रेजेंटेशन दीजिए। You can, bar can give a representation that it should be made available, and you can also cite instance कि दिल्ली हाई कोर्ट में ऐसा
Yes.
होता है, तो we can
We have
have
to
a
just move an
discussion with
application to the
honorable
court
chief
master
justice.
there in Delhi.
he says that in court number 6
They have started.
with the order.
Get the copy in the pen drive of
You
our.
take it, एक precedence है तो आप ले लीजिए, कोई दिक्कत नहीं।
Much.
But he may verify.
हाँ, he may verify
Yes.
from court
Generally,
number 6.
that would
So
be-
that becomes easier for me to just go through the tab and for the entire records.
This
There in Delhi,
technology
we
is
are
meant
not
for
carrying
this.
any physical files these days. Physical file is seen as something a taboo. Everybody has got a tab, and we keep juniors that they have to basically simultaneously have the tab to keep on showing to the court,
You must be working in liquid text. यहाँ पे नहीं है ना?
and we keep on
यहाँ पे
airdropping.
your
We
courts-
airdrop to the court master.
Your courts must be also working in liquid text. तो यहाँ नहीं है ना?
Liquid test is there.
तो
Liquid
कुछ ऐसा
test
करिए
is
कि यहाँ भी
something
हो जाए।
which is really revolutionized everything. Liquid test.
I was trying to use liquid text, but we could not synchronize it with our system. और यहाँ से कोई डिमांड नहीं है वकीलों की।
That will
उनको
be.
पता भी नहीं होगा। I don't know. Have you heard of liquid text?
Yes, yes. But your lordship, it is not convenient for our files. That means appeals.
हम
It
लोग
is
का
difficult.
synchronize नहीं करता है हम लोग के साथ। Simultaneously multiple documents खोल सकते हैं। Simultaneously multiple चीजें देख सकते हैं। That is designed for
And
judicial
here
work.
what we get is our villagers. The clients are mostly villagers. When
This
they
is for
Clients
the
are
come
lawyers,
villagers,
to us,
this is for the
litigants are not
lawyers.
villagers.
So-
You are not villagers.
no, when the file comes to us, it is difficult to convert it into any PDF and then that difficulty.
That takes, this is a transition phase for every court. We were there in the same position 5 years back during the
How
COVID.
much time did you take to start operating a phone, smartphone? I
Within-
took the transition for 15 days.
Within a day or two.
नहीं, हमको तो 15 दिन लगा था समझने में कि स्मार्टफोन कैसे यूज करना। But transition takes a time.
Actually what we have seen that lawyers are hesitant at times. But the moment they start doing it, it becomes so convenient that we say that why we have not used it earlier. And we keep on airdropping everything, the judgment to the court
आपको मैं
master.
बताऊं, इतने सारे फोटोकॉपी हमारे पास इकट्ठे हो जाते हैं। But I am dead sure that if I want to revisit any judgment amongst that photocopies, I will not be able to do it. ये इतना मुश्किल है ये फोटोकॉपी से चीज़ों को देखना। लेकिन फिर भी बहुत अच्छे से हम लोग नहीं ऑर्गेनाइज हो पाए। झारखंड नहीं हो रहा है। इस ट्रांजेक्शन वैसा कोई बाहर से डिमांड भी नहीं रहता। There is no such demand कि हम लोग उसको synchronize करें, ऐसा कोई demand नहीं है हमारे पास। We are taking our own time।
There the bar is very proactive.
नए लोग आए हैं।
Mainly the IPR lawyers.
हाँ।
IPR lawyers, they come out with technology every week.
Because IPR as a sector is backed by technocrats. You have IPR having
And the main reason that
engineering
we
in
have the
IPR,
original side in the High Court.
engineering in IPR plus law. जितना भी law firms है वो engineers are working in IPR. So उनको तो
I've
उसके
seen,
बिना नहीं
I've met one of the lawyers who was a patent, she did patent from IIT Kharagpur.
हाँ, there
And
are
she was doing the,
numerous जितना भी IPR firm है as I understand.
they are all hiring.
They are all backed by technocrats.
And they are basically pressing because we in Delhi High Court we have original side also. That is the main reason for IPR.
थोड़ा time लगेगा हम लोगों को।
much obliged. I'll be there on Monday.
हाँ पेन ड्राइव में अगर हम लोग पता कर लेंगे तो आपको
Please, much obliged.
Orders
Soft
verified.
copy is already there.
इट्स ऑलरेडी देयर हम लोग थोड़ा पता कर लेते हैं कोर्ट नंबर 6 से पता कर लेते हैं अगर कहीं पे
We
मिल रहा
record
है
that I have given the written synopsis and the judgments to the other side.
और वो हमें सॉफ्ट कॉपी प्रोवाइड
Soft copy.
हाँ
I can,
हमारे कोर्ट मास्टर को दे सकते
can I just email to the court master? I have that capable.
हैं। कैसे लेते हैं पेन ड्राइव में लेते हैं सॉफ्ट कॉपीज रिटन सबमिशन
Email,
मेल आईडी
mail ID मुझे दे दो. Both the written arguments and judgments are email also for the convenience of
दैट्स
much.
Orders verified item 4. First appeal 86 of 2024.
Only one temper. Today, all the next temper week will be today itself, but today next week not. During vacation, I could not do it. Only today itself, only one today. Only one day.
ओनली वन डिफरेंट यू
Yes.
वांट टू रिमूव इट ड्यूरिंग द कोर्स ऑफ
Certainly,
द डे
today itself I am doing.
FA number 86 of 2024, learned counsel for the appellant, prays for and is allowed to remove the defects during the course of the day. Post this case day after tomorrow on the rapid date.
Not next Monday.
परसों
Next.
परसों अब बाहर जा रहे हैं
बाहर नहीं जा रहे, सिर्फ इसमें 4,500 का कॉपी फाइल करना है।
आज ही करेंगे ना
हाँ, आज
कर दीजिए
आज से कल तक कर देंगे।
आज से कल तक तो आप नहीं बोले
मैंने-
आप बोले आज ही करेंगे
हाँ, आज हम पूरी कोशिश कर रहे हैं, इसलिए हम सिर्फ नेक्स्ट मंडे का कल इन्फॉर्मेशन मांग रहे हैं। सिर्फ आज हम कर देंगे।
देखिए आपने बातों को चेंज मत किया
नहीं चेंज कर रहे हैं, सिर्फ मंडे।
आपने बोला कि आप ड्यूरिंग द कोर्स ऑफ द डे चेंज करेंगे हमने परसों रख दिया
उसको सिर्फ फ्राइडे पर दो दिन का समय मिल जाएगा। सिर्फ एक लार्ज अमाउंट है,
आपने 2-3 दिन का समय मांगा नहीं इसीलिए आपसे बोला
हम तो प्रयास अपने प्रेयर के
अभी प्रेमटी ऑर्डर कर देते तो क्या होता
वो सिर्फ 1 वीक कर रहे हैं, सिर्फ नेक्स्ट मंडे कर देंगे। नेक्स्ट
इसमें कर दीजिए विद इन 1 वीक ट्यूसडे इन सप्लीमेंट्री लिस्ट प्रेमटी कर दीजिए विद इन 1 वीक प्रेमटी कहानी मत हमको सुनाइए
हाँ ठीक है।
चलिए नेक्स्ट
For hearing item 14, second appeal 214 of 2016.
Who is for the appellant? Who is for the appellant in this case? Essay number 214 of 2016. Nobody appears on behalf of the appellants, on behalf of the parties. Close this case for final disposal on 18/6/2025. It is made clear that no further adjournment will be granted. Next. क्या? 14 क्या है?
यही same.
You are for the appellant.
Yes, Mother Rajiv Kumar will argue this case, Mother.
You are praying for not today.
Yes, Mother.
Tomorrow.
Tomorrow.
Not today मतलब क्या? I only know not today means tomorrow.
ठीक.
ठीक कल कर. इसको listen. Counsel for the appellant. Prays for not today. Let this matter be posted tomorrow for final disposal.
Item 15, second appeal 361 of 2016.
Nobody appears on behalf of the respondents. आप अदर साइड को खबर करेंगे स्टेट है ना अदर साइड खबर कर दीजिए Yes,
I
please.
pray for a short passover.
Passover.
Yes.
Who will argue this case?
Mr. Sudhir Kumar Sharma for the applicants.
What is the question of law involved?
I'm sure I beg your pardon. I'm not aware of the case at this present point in time.
What were you doing during vacation? Celebrating vacations.
No,
Then,
I just-
what were you doing during vacation?
I just came to
First
know
case you do not know.
I just came to know about the case revision a day before yesterday. I was reading other cases. I beg your pardon.
You were reading the cases, no? This case you must have read.
No, Your Worship, I beg your pardon. I have
What's your name?
Rashid Pradhan.
How long have you been practicing?
It's been 2.5 months.
What is the substantial question?
Substantial question of law from a legal perspective is given under section 100 of the CPC.
No. What is the substantial question of law involved in this case?
I beg your pardon, Your Worship, I am not
Substantial question of law is framed in first appeal or second appeal?
in second appeal, Your Worship.
Why not in first appeal?
Because first appeal happens to be a stage where the fact can also be questioned and fact can also be legally adjudicated.
Call your senior. It will be taken up at 11:30.
Item 16, second appeal 402 of 2016 along with item 17.
No, I'm the one who's trapped now. The question of law, it was a, I'll just brief Your Lordship, but I'll pray that next week if Your Lordship takes it. Today is the first day of the week. I'll just start.
Not for you.
First is, Your Lordship, it was a partition suit which was filed by the respondents hearing. That partition suit, two schedules were involved. One was Schedule B and one was Schedule C. With regard to Schedule B, the trial court decreed the suit, and against that we preferred this. The first one is with regard to that itself. One appeal is with regard to concurrent finding on the facts of partition, and the second one was with regard to the Schedule C property, which the trial court did not allow partition on the ground that those were recorded in separate names of the plaintiff side and the defendant side, and the trial court very specifically held that the plaintiff had failed to bring anything on record to show that there was a nucleus from which those properties were purchased, and therefore the trial court held that it was not a joint family property, and therefore with regard to the claim of partition Schedule C, the trial court rejected that. So the first appellate court, without meeting the reasonings of the trial court, it only directs partition of that Schedule C, without dealing with the reasonings.
This is the substantial question of law in both the cases?
No. In one case, the substantial question of law in the second appeal number 393 of 2016 is related to concurrent finding, where the question of law is whether the courts below have misconstrued section 18 of Hindu Succession Act while dealing with the law of succession regarding inheritance of property of goodwill. So here was a question where the original ancestor had 4 sons. From the first wife he had 1 son, from the second wife he had 3 sons. So
So I just want to know, when you say that the first appellate court did not meet with the reasons of the trial court, what are the remedies available? What are the courses available for the court? We can still go into the facts of the case.
there are two. First would be that Your Lordship, because there is a clear finding of the trial court which the appellate court reverses without meeting, the one course may obviously be remand of the matter to the first. But the second would be that Your Lordship, there are several judgments of the Honorable Supreme Court where it has said that if there are different findings of both the courts, then the High Court can interfere even under Section 100 of, while dealing with the second. So,
While dealing with the second appeal, the court can enter into the fact when there are different findings of both appeals. But considering the nature of question of law which has been framed, will it be open to this court to enter into that? Because the question of law is whether the first appellate court is justified in reversing the finding only with respect to issue of law.
yes, this, if it is answered in my favor, then it calls for a remand. That is all. But the second one would be in the same case, Your Lordship, that is.
This is only with regard to issue number 9.
Yes, and this is involved in, this question is there in Second Appeal 402 of 2016, where there was a reversal.
That's right.
So, if there was a reversal and the Honorable Court has framed this particular question, the another question would be whether the finding of the trial court with regard to that there was no nucleus, the plaintiff had failed to prove any nucleus, the appellate court could have reversed that finding without holding that there was any nucleus. The appellate court does not even whisper a single word that there was the trial court's finding is bad because there was a nucleus and therefore this.
Are you there for the other side of this?
For some of the respondents, I am
That's enough. We don't bother for those who are not appealing. We are not going to wait for those who are not appealing. Non-appearing parties, let them speak.
So far as the matter which is on board today, I am ready in the first matter.
You see, not the first. It is arising out of the same judgment.
Same partition
That
suit.
is just a moment. It is not so easy as I see that there are other issues and whether Mr. Sharma, you just tell us the substantial question of law which has been framed in second appeal number 402 of 2016 with respect to issue number 6 that the first appellate court has not considered the reasons of that. What are you looking at? Are you looking at a remand or you are looking at a decision by the Supreme Court? Now there are two different parallel findings. So if you are looking at a final decision from this court, we'll look at from that angle. Or if we otherwise see that this has not been actually met. Because when we talk about nucleus, it requires appreciation of evidence. It is not straightforward.
If I am able to satisfy that the substantial question of law which has been framed does not exist.
So you want to address on that also?
That I will argue. But not today.
No, you see, you will argue that, but you will argue before we actually open the file on merits. Because the moment you will start your argument, then we will hear you first before actually crystallizing on substantial question of law. If we ultimately find that these questions of law does not arise, then we will stop at that.
Yes.
Simple.
That's what I am saying.
So the argument will be started at your end.
No matter it will be argument prerogative.
No. If you see that these are not the substantial question of law which arises for
We
consideration.
should argue first that this is the substance of law which
Yeah, well, how does that make a difference? We are on the records. You can also start that this substantial question of law has been framed and it does not arise for consideration. This opportunity you will certainly have.
this is the only thing which I would like to argue.
Then we will hear you first.
But my lord, I very humbly submit, not today, any day other day,
Tomorrow.
if possible in the day.
तो आप हमको बताइए हम पूरा दिन क्या करें
हम 15 नंबर में रेडी आई विल आर्ग्यू
और अदर से
अदर साइड का तो हुजूर नहीं करेंगे लेकिन बट आई एम रेडी इन दैट मैटर आई एम ऑलरेडी रेडी आई विल आर्ग्यू टुडे इटसेल्फ
in both the appeals you say that these are not the substantial question of law which arises for consideration. In only one of them.
but
Because Section 18 of the Hindu Succession Act is certainly a question of law.
That question of law can arise, but that I will not answer today.
I'm not asking you to answer today. Let me just figure out the contours where you are landing up.
But in my humble submissions, I have gone through the judgment long back today. I think that the order passed by the appellate court.
That's a part of your duty to submit that.
But that
It's an admitted second appeal, right?
I agree.
Either I have to answer it, or I will be satisfied that it does not arise.
Yeah, I agree.
So you just can't say that the order has been.
Once a substantial question of law is framed by any order, this honorable court, as per the mandate of section 100, it has to be answered.
That's right.
I agree to that.
There are certain circumstances where they are seeking a remand, then we just keep it open. Because other substantial question of law also become a part of fact and law.
Yes.
So that can be done, that too, most of the time the parties agree to that.
Yes.
Because that, but this particular thing कैसे होगा? आप ऐसे नहीं करिए भाई. अभी तो कोर्ट खुला है, आप लोग टाइप चाहिए आप लोग.
मैं आज शिफ्ट है इस मैटर 15 हम मालूम करें
15 तो हम पढ़ के नहीं आए ना.
हम पढ़ के आए
हम नहीं जानते हम पढ़ के.
हम पढ़ के आए 15 हम पढ़ के आए
तो फिर आप लोग नोट्स भी बनाए. फिर आप लोग नोट्स भी बनाए.
ये
इतना
16
होमवर्क तो आप लोग को लेना होगा. इतना होमवर्क तो आप लोग को लेना होगा.
16 17
हाँ
15
15 को क्या हुआ? 15 से एडजर्न हो गया. अच्छा पास ओवर है. वो तो
है
बहुत आसान है. आपको क्या प्रॉब्लम है? आपका जूनियर बहस करता तो हम आपके बिना ही अलाउ करते.
इसी को कह देते हैं
एडिशनल एविडेंस रिकॉर्ड पर है जिसका कोई एडजुडिकेशन नहीं हुआ है. देयर इज एन ऑर्डर that additional evidence will be taken up at the time of final disposal. जब एडिशनल एविडेंस रिकॉर्ड पर है तो हमारे पास ऑप्शन ही क्या है? सेकेंड अपील में तो एडिशनल एविडेंस लेके नहीं डिसाइड करेंगे ना.
उस मैटर में रिमांड इज वारंट
तो इसके लिए तो आपका जूनियर तैयारी नहीं
और
क्या.
उस पॉइंट उस पर्टिकुलर केस में आई विल आर्ग्यू दैट पॉइंट उसमें खेवट
कुछ आर्गुमेंट की जरूरत नहीं है. एडिशनल एविडेंस रिकॉर्ड पर है, कोर्ट बोला है कि हम बाद में कंसीडर करेंगे. बात करता हम उसका मेरिट पे क्यों जाएंगे? उसका क्या रेलेवेंस है, नहीं रेलेवेंस है. हम थोड़ी सेकंड अपील में इसको डिसाइड करेंगे.
उसको हम
तो ओपन एंड शट कैसे
उसको
आप
बात करते हैं ये वाला
आप इतने सीनियर हो के आप हमको क्या बेवकूफ समझ रहे हैं?
नहीं
क्या एडिशनल एविडेंस
इसको नेक्स्ट
आपको लग रहा है हम पढ़ के नहीं आए हैं?
इसको नेक्स्ट हम
2 दिन से फाइल पढ़ रहे हैं आप लोग का भाई.
ये इसको आज फ्रैंकली my friend must be ready I hope
no
वो भी नहीं रेडी है.
he is always ready
चलिए कब करना है बताइए.
next week
if your lordship says the moods then next week again 2:15 your lordship has
Monday
fixed
को तो
another
रखे हैं.
matter on 16
देखिए ऐसा करते हैं इसको. इसको हम रख देते हैं थर्सडे.
ठीक
I will hear on you first your point. ठीक, this substantial question of law does not arise from constitution. And then if I am satisfied that it does not arise, then I call upon him. तो substantial question of law को justify करने के लिए तो इनको notes बनाने की ज़रूरत नहीं है. और otherwise we will hear it and then you can file your submissions on the next day. Thursday रखते हैं.
ठीक है
ठीक. Second appeal number 402 of 2016 with essay number 393 of 2016. The learned counsel for the respondent.
not for all respondents but I am for few respondents I am
For some of the
for
respondents
some
has
along
submitted
with my
that
friend Mr. Sandeep
the substantial question of law which has been framed in the present case do not arise for consideration as they are not substantial question. He submits that he shall advance his argument on this aspect of the matter on the next day with the consent of the parties pose this case on Thursday for final disposal. Thursday कौन सी
2:15.
तारीख है? हाँ 2:15. Thursday.
This week,
हाँ.
12.
हाँ 12 तारीख at 2:15.
2:15
वो जो मैडम है ना यहाँ पर कौन है? होल्ड दिस फाइल। अपना अपीयरेंस दे देंगे, पता नहीं कौन कौन अपीयर कर रहे हैं। पास ओवर 11:30 बजे रखते हैं। अदर साइड कौन है उसमें? हाँ हाँ इन्फॉर्म कर बुलाइए बुलाइए, बस वैसे 11:30 बजे रखें, और नहीं भी आएंगे तो भी डिसाइड करेंगे, खबर कर दीजिए, उनका नाम फ्लैश कर दीजिए, स्टेट काउंसिल का।
Ultimately, second bit 261 of 2017.
215 your lordship, I'm agreeing. 215.
क्या मतलब हम लोग क्या करें? आप सारे केस
नहीं
का
ये
टाइम
इनका
मांगिए।
केस है ना, शर्मा जी readily agree.
Readily he agreed, I don't agree. ऐसा नहीं करिए, ऐसा नहीं है। खोलिए इसको, फाइल खोलिए, ओपन द फाइल। LCR कहाँ है इसका?
हम लोग दोनों थोड़ा टाइम
अच्छा ये आपको भी टाइम चाहिए?
थोड़ा सा छुट्टी के बाद जागने में टाइम लगता है।
हम लोग तो सोए ही नहीं।
Your lordship is hard working.
थ्रूआउट द वेकेशन बहुत सारे अपलोडिंग वगैरह पेंडिंग था। बढ़िया। और याद कर रहे थे अपने वकालत के समय।
हम कोशिश कर रहे हैं अभी। And just
ऐसे
give a
पार्ट
brief
पार्ट में नहीं
synopsis and
होगा,
then-
पार्ट में नहीं होगा।
अच्छा ठीक।
आप लोग आ जाइए, आप भी
जी।
तैयार हो जाएंगे तो अभी तो बहुत टाइम है, थोड़ा फाइल पढ़ लीजिए सर। ये 215 बोल रहे हैं। आई डू नॉट नो, अगर आप तैयार हैं अभी तो हम अभी सुनें।
इसको नेक्स्ट मंडे रहती है।
नेक्स्ट मंडे।
पाठक
आपका कोई भी केस 3 बार बिना एडजर्न हुए नहीं होता।
पाठक करके रखिए।
पाठक नहीं करेंगे ऐसे, बिना एडजर्नमेंट के कौन सा केस करेंगे?
रीओपनिंग, स्कूल का रीओपनिंग होता है ना,
स्कूल का रीओपनिंग में आज
ईयर
से
अप होने में टाइम लगता है।
कल से है डीपीएस का रीओपनिंग, पहला दिन एग्जाम है, इसलिए वो जमाना खत्म हो गया रीओपनिंग का काम। नहीं ऐसे नहीं करेंगे, आप आ जाइए, आप इतना तो बहुत है, 2 घंटे।
नहीं then your lordship tomorrow 215. Tomorrow 215.
ठीक।
कल we'll both would be.
कल एक रखे ना मैटर हम लोग।
कल tomorrow पे क्या है? First, second,
कल एक गया है, आज करिए ना, आज करिए, क्या दिक्कत है? आप 2 घंटा है, आप तो 215 ही मांग रहे थे ना आज।
हम मांग रहे थे, हम तो नेक्स्ट वीक बोल रहे थे, लेकिन नेक्स्ट वीक हम नहीं बोल रहे।
नहीं आज हम लोग एक
कल
नया,
के लिए बोल रहे।
आज हम लोग एक नया इनिंग शुरू करेंगे,
अच्छा,
जिससे
कल
सहाय का
फिर-
केस बिना एडजर्नमेंट के डिसाइड करेंगे।
कि मेरा केस नहीं, इनका केस है।
नहीं आपका केस।
अच्छा कल 12:30 है। We both are agreeing and making a joint plan. I'm not saying it. Sharma ji, he has already given a remand matter for which he would be taking some.
डिमांड से हम बहुत खुश नहीं होते क्योंकि लिटिगेशन खत्म नहीं हुआ।
No, खत्म तो नहीं।
नहीं, कोर्ट क्रिएट करता है वैसा सिचुएशन। ऑल्दो दूसरे कोर्ट में एक मैटर I would have placed before this honorable court.
ऐसा है मिस्टर, आप इसको थोड़ा सा शुरू करिए, लेट अस सी द क्वेश्चन ऑफ लॉ, उसके बाद हम कल कीजिए, कम से कम थोड़ा दे, कम से कम कंक्लूड्स ऑफ योर आर्गुमेंट, लेट जस्ट स्टार्ट।
ठीक है, तब then 215 में।
ठीक है, स्टार्ट आप करिए,
ठीक
इन कंटिन्यूटी हम लोग कल करेंगे।
ठीक ठीक।
ये फाइल हमको देंगे।
अब ले लो।
Item 19, second bit 274 of 2017.
Yes, appellant. Appellant.
After two cases.
क्या 2 केसेस का क्या कहानी है भाई?
215.
इतना सिंपल सा सब्सटेंशियल क्वेश्चन ऑफ लॉ बना है, इसमें क्या 215 आप होगा? अब बहस करिए 16(1)(c) का है स्पेसिफिक।
215.
एक रखे हैं 215। The train is delayed. शुरू करिए एकदम स्पेसिफिक रिलीफ एक्ट का केस में वैसे भी ज़्यादा दिन पेंडिंग नहीं रहना चाहिए। रेडीनेस एंड विलिंगनेस पर ही होगा। पढ़िए।
इसको 215.
कैसे करेंगे?
215.
And you?
But our case is not like that. But both the
Ready? ये ready.
trial court as well as appellate court lordship, both the courts have decided against the appellant. Concurrent finding by the trial court.
Once a substantial question of law has been framed, I have to see everything.
Lordship, that,
I will see
that
all
has
the
to be
evidences
seen,
also.
but there is no readiness and willingness on part of the appellant, as well as the agreement itself, my lords, is not enforceable as lordship. The one of the party who was my lords the executant in the agreement, but she withdrew from the agreement, and she is not a party in the suit.
That is not a substantial question of law.
No, that was not considered by the learned
We
bench.
We will confine ourselves to the substantial question, and that is all.
Because the agreement itself is not enforceable in the eyes of law.
Is it a finding recorded by both
Lordship,
the
it is
courts?
also finding recorded by the London First Appellate.
सुन लीजिए Mr. Sharma, there is a finding recorded by the first appellate court that the agreement itself is not enforceable. तो readiness and willingness का क्या ही आप बहस करेंगे?
Yeah, I have. 215.
टाइम नहीं देंगे आप, ठीक है? आ जाइए। टू 215 में जो नहीं आएंगे ना उनका केस अब डिसमिस कर। 215 रखवाने के बाद इफ यू सीक टाइम बहुत हेवी कॉस्ट करने वाला, बी वेरी केयरफुल अबाउट। अब बस दूसरा डेट नहीं होगा।
Item 20, second appeal 591 of 2017.
In this case, my lord, I am not ready today because I was suffering illness, and yesterday I came to Ranchi. Therefore, to next week, Monday, Tuesday, any day of the day, I will. काफी तबीयत खराब थी और ऊपर भी नहीं आता, बहुत मोटा फल। Only either Monday, Tuesday, Wednesday, any day, my lord.
हमारी हलमन साहब का फायदा मत उठाइए।
नहीं, हम नहीं उठाते हैं।
बाकी सब जगह 1000 रुपए कॉस्ट होता था, हम 1 लाख रुपए से कम किसी केस में कॉस्ट नहीं करेंगे। हम बता दे रहे हैं बात। If it is taken as a routine कि हर केस में एडजर्नमेंट मांगना ही है, तो
नहीं, हर केस में हम कभी ऐसा लिए नहीं है।
भाई हर केस में तो अलग ही काउंसिल आते हैं ना।
नहीं, इस केस में नहीं, इसमें नहीं। इसमें
हर केस में तो we have a different set of
हम
counsels.
एब्रॉड चले गए थे, परसों ही आए हैं और जेट भी हो गया था, तबीयत भी खराब थी, फीवर भी हो गया था, इसीलिए आज जस्ट और कोई बात नहीं। तो अब नेक्स्ट मंडे कर दिया जाएगा, ट्यूसडे, वेडनेसडे, एनी डे।
पहले भी आपको कॉस्ट जमा करके ही टाइम
लगा जो इसके माय पर्सनल रीजन के चलते
क्या पर्सनल रीजन
हम इस बात नहीं कर पा रहे, इसीलिए आई एम नॉट रेडी टुडे। एनी डे नेक्स्ट वीक, नो फर्दर।
देखिए ऐसे नंबर 591 और 2017 are you there for the respondents? Learned counsel for the parties are present. Counsel for the appellant has strenuously prayed for adjournment by submitting that he had gone abroad and has returned only day before yesterday.
Yes.
Correct? and he is not in right state of mind to argue the present case. On earlier occasions also, the matter was adjourned upon payment of cost. However, considering the prayer made, the matter is adjourned and is directed to be posted on Monday to be taken up at first case at 10:30. नहीं आइएगा, हम डिस्कस कर देंगे. पास ओवर नहीं देंगे.
नहीं नो पास.
फॉर फाइनल डिस्पोजल, ये जितने भी मैटर जा रहे हैं ना, सब फाइनल डिस्पोजल में डालें. नहीं तो केस थका जाएगा कहाँ से.
Item 21, first appeal 126 of 2019.
In this case, Lordship, Mr. Vishal Kumar Tiwari arguing this case.
They rejected.
Lordship, he is on leg in court number 4.
तो शुरू करिए ना.
So it
उनको
will
भी
be
सुनेंगे.
250.
नहीं हो सकता. कोर्ट 10:30 बजे से शुरू होगा.
Lordship, actually हम आज ही आए तो Lordship हम तो उतना रेडी हैं नहीं. एक्चुअली फाइल तो वहाँ रखा हुआ था सीमेंट के पास. और इट विल बी टुमारो एज ए फर्स्ट केस.
आपने देखा है कल? आई हैव नॉट सीन.
Lordship, दो है ना, तो दो में से कोई एक तो रहेंगे.
कौन?
मैं और मिस्टर विशाल कुमार तिवारी भी हैं. Lordship.
हम तो नहीं भी रह सकते ना. हमको नहीं कोई गारंटी है कि हम कर लेंगे.
सब
यही लाइफ है. This is how the life.
रहेंगे Lordship, ऐसा कैसे हो?
We have seen records कि ऑर्डर बना हुआ है, जज सामने साइन नहीं कर पाए. एक नहीं, कई रिकॉर्ड्स नहीं करे. इसलिए कल का तो बात ही होती है.
आज के लिए दो
क्या मैटर है बताइए.
पार्टीशन सूट है Lordship, ये तो
Formal respondents हैं Lordship.
फॉर्मल रेस्पोंडेंट है.
Lordship,
आप कौन है?
Respondent number 5 and 8 Lordship.
actually Lordship,
कंटेस्टिंग रेस्पोंडेंट
I
कौन?
am for respondent number 1.
कंटेस्टिंग. सर बताइए क्या मैटर है, कुछ तो बताइए.
पार्टीशन सूट का मैटर है Lordship, सिमिलर फैमिली का है.
प्रीवियस पार्टीशन की कोई कहानी है इसमें?
यस Lordship, वो 64 का
प्रूव हुआ है?
Lordship, एज पर अभी तो उतना रिकॉल नहीं कर पाया, लेकिन जो है उसमें Lordship है कि उसके बाद वो जमीन जो है वो एक और किसी को ट्रांसफर किया गया इस फैमिली के द्वारा. फिर 96-97 में ये जो डिपेंडेंट नंबर 1 है उनके यहाँ कैसे एक्सक्लूसिवली चला गया, ये Lordship प्रूव नहीं हुआ, जैसा हमको ध्यान है Lordship.
क्या है सर, बोलिए.
आज पढ़ नहीं पाए.
इनको तो पता ही है.
Let suit for partition. This was on the ground that the property in question was already sold prior to filing of suit. There is no unity of title and possession between the parties. As suppose the dependent, they were debarred from filing written statement. Ex parte alias dependent were 3. Only the contesting dependent is dependent number 1.
Who is the purchaser?
Yes.
No.
I am representing.
You are the purchaser?
Yes. No, not purchaser.
No.
I am the only contesting dependent.
Okay. All right.
One of the
You must have sold the property.
The other plaintiff and
Property was sold by whom?
Plaintiff and his ancestor have already sold the property.
And that was the only property subject matter of partition.
Yes. Therefore, the suit was dismissed on very grounds. First is,
टोटल एरिया Lordship 5
plaintiff was not examined.
आप पास ओवर मान रहे थे ना?
जी.
बुला के लीजिए.
Lordship, अभी तो बहुत चल ही रहा है.
कोई बात नहीं चलेगा. यहाँ पर हम बैठे हुए हैं. बुला के लेके आए.
ठीक.
12 बजे.
Lordship, उनका खत्म हो रहा, बुला लेंगे.
नहीं 12 बजे क्योंकि 11:30 बजे एक मैटर हम लोग रखे हुए हैं।
Item 22, first appeal 37 of 2020.
Malady, in the present matter, the respondent has died.
Respondent number 1, Dr. Nutan Means has died, Your Worship. I am appealing for the respondent number 1.
When did she die?
15th May.
This 15th.
Yes.
FA number 37 of 2020. Learned Counsel for the parties jointly submit that respondent number 1, Dr. Nutan Means, has expired on 15th of May 2025. They seek adjournment. How much time do you need?
1 week.
Post on.
And if in the meantime he gets the wakalatnama, it can be heard.
वकालतनामा सब्स्टिट्यूशन अलाउ करना पड़ेगा।
हाँ मतलब
सब्स्टिट्यूशन के साथ आप अपना वकालतनामा फाइल करते हैं।
because
अच्छा
yes,
आप
First they have
yes, I'll
आप आपके पास है लीगल हियर्स एंड सक्सेसर्स का पता दे दीजिए क्योंकि उसके बाद सब्स्टिट्यूशन का रिप्लाई का स्कोप खत्म हो जाएगा है ना द काउंसिल फॉर द रिस्पोंडेंट अंडरटेक टू प्रोवाइड the list of legal heirs and successors of respondent number 1 to the learned counsel for the appellant along with their present and correct residential address.
Just for a moment, they are the own brother. This step brother, the appellant is the.
You were holding wakalatnama on behalf of respondent number 1.
Yes.
बस आप दे दीजिए.
They fully know.
With their present and correct address. Within a period of 1 week, right? Pose this case on next Monday.
he could have given it 2 days. I'll be filing within 1 week.
Yes, mobile, today itself.
आप दे देंगे आज?
हाँ, आज
ठीक है. By tomorrow?
Yes.
Pose this case on Monday.
We'll file it
Monday?
within a week.
आप वकालतनामा ले लीजिए. ठीक है? चलिए. आज दे दीजिए. ऑर्डर असाइन करके अपलोड कराइए.
Obliged.
Item 23, first appeal 49 of 2020.
Yes, appellant. Where is he? नहीं ये सब आप खुद सीनियर हो चुके हैं आप बहस करें You are the retained counsel of Food Corporation of India. You are also the retained counsel. हमको कहानी मत सुनाइए हमको सब पता है. You are also the retained counsel. हाँ? किसका? 2 साल नहीं हुआ. हमको लग रहा है कम से कम 6-7 साल से आपको जान रहे हैं.
I am practicing since January 23.
लेकिन आपका स्ट्रेचर 6 साल कितना तो हो गया. आई एम बीइंग वेरी काइंड. आपको देखिए 6 साल का प्रैक्टिस का सर्टिफिकेट हम आपको देते हैं. आपको बेस्ट मनी डिग्री है क्या कर रहे हैं?
So कल फाइनल डिस्पोजल मिनट हुए. सीनियर से बात हो जाता तो आज ही हो जाता.
अच्छा शुरू तो करिए ना. कल हम आपके सीनियर को सुन के बैठ.
एक दिन नहीं फाइल लिखा हुआ लीडरशिप से. हम तो रिक्वेस्ट है जो कल करेंगे.
सीनियर फाइल अपने साथ लेके चले जाते हैं.
मैं भी आउट ऑफ सेशन था इसलिए फाइल देखी. Else I would have not sought. Tomorrow रख दीजिए पॉजिटिवली करें. कॉन्फिडेंस में आर्गुमेंट हुआ था उसके बाद रजिस्टर चेंज हो गया. पॉजिटिवली बता दिया.
कितना केस हम ऐसे टुमारो करेंगे बताइए. कहाँ है आपके सीनियर?
कल हो जाएगा लड़के.
एक दिन पहले तो बाहर से आना चाहिए ना. 2 दिन पहले.
ऐसा मतलब कोऑर्डिनेशन प्रॉब्लम है. हम लोग दोनों को सिंगल जूनियर ऑफिस में कल पॉजिटिवली मिला.
एग्जीक्यूट नहीं किया मनी डिग्री.
इनका मनी सूट फाइल बाय हिम वाज
अच्छा
डिसमिस्ड.
डिसमिस. अच्छा इन्होंने फाइन किया था ना. आपका तो कंपनी है, अब कॉस्ट लगाइए. पहले भी कॉस्ट लगा हुआ है.
कॉस्ट नहीं लगा रहे
थोड़ा
पॉकेट
सा.
से लग गया प्लीज.
थोड़ा सा कॉस्ट हम लोग अपने पॉकेट में नहीं डालते हैं. आपके वो कौन सा है एडवोकेट
नहीं विद फोल्डेड हैंड्स आई हम लोग के पॉकेट से
कंपनी को फोल्ड हैंड्स फोल्ड करने की कोई जरूरत
प्लीज
नहीं.
योर प्लेट्स
वो आ गए क्या आपके सीनियर बहस करने के लिए रेडी है. चलिए आगे करिए. बाहर बैठ के वीडियो देखते रहते हैं, हमको पता है. ऐसा रिपोर्ट हमको मिला. झूठ नहीं बोल रहा.
आई डोंट
मेरे पास मल्टीपल आंखें हैं.
नहीं आई डोंट मेक फॉल्स एनालिसिस.
नहीं फॉल्स नहीं, वो बाहर बैठ के वीडियो देख रहे हैं.
ये बस आ रहे होंगे वाज ऑन द वे अब डिस्प्ले देख लिया होंगे.
चलिए चलिए हाँ बताइए. एलसीआर देखिए. बताइए. प्लेट. प्लेन पढ़िए.
I don't have a copy of the plain, the entire certified copy we worked in, but
Whatever is recorded in the impugned judgment is correctly recorded.
actually most of it is correct.
फर्स्ट अपील में है ना.
First
कुछ भी इनकरेक्ट होगा तो who will bear the responsibility?
correct.
You just argue in your own manner. चलिए. You can place it from the judgment also. Plain and written statement तो more or less ठीक ही लिखा रहता है, unless they have some objection.
Gist is that the contractor, Arvind Kumar Sinha, he was appointed as a handling and transport contractor for handling of food grain at Railhead Hazaribagh, for transportation of food grain from Railhead Hazaribagh to the CWC, which is Central Warehousing Corporation, go down at Hazaribagh, and at another go down at Surya in the same district. So this was the contract. The contract was a tenure contract. The contract I'll place, it is Exhibit 16, which is the material document and which has not been taken into consideration at all, also while deciding the question of limitation against the appellant. The contract was a tenure contract, it was for a period of 2 years from the date he assumes charge. The index date list of dates is there. There is only one minor error in the list of dates. The termination date is wrong. Apart from that, all the dates are recorded
Where
in
is the index?
index to the memo of appeal. Sorry, the synopsis to the memo of appeal. So tender was floated on 22/7/1994, and he participated in the tender and he had quoted the lowest rate of 181% above the schedule of rates mentioned in the contract. Thereafter, he was given a appointment letter 110/1995.
The commencement period was 2 years commencing from 22/5/1995 as per the
Correct.
synopsis.
Yes, 22/5/1995, because he gave his acceptance and assumed the work from 22/5/1995. So it was for a period of 2 years. However, barely after 4.5–5 months, our case is that he abandoned the contract. He did not do any work.
He did not do any work.
He did not do any work after 4.5 months. For 4.5 months he did work. After 5 months he stopped all work.
When did you terminate the contract?
13/2/1996.
Commencement. 13/2/1996. Termination.
We terminated because he stopped doing any work, did not make payment also. There was
When did you file the suit?
The suit was filed in 1999.
24 December
1999.
24/12/1999. Barred by limitation. The
That
cause
is-
of action is, the termination.
No, Lordship, that is exactly the point that we will raise, that the contract is not for a fixed period. I do not incur the loss when I give the letter of termination, because it is a tenure contract and it is not a fixed volume of work contract. Particular volume is not guaranteed. The contract is whatever food grain is received at the railhead has to be transported. Now it cannot be determined, predetermined what
You just tell
quantities.
us. Once you terminate the contract, how do you assess the loss beyond 13?
Correct. So we say the contract itself
You are
says.
not entitled to recover.
No, we are entitled to recover because the contract itself says
You terminated it.
we terminate.
Once you terminate it, the rights and liabilities of the parties crystallizes on the day you terminate the contract.
Provided, the contract itself specifies that if you fail to perform the contract, then it will be carried out by another contractor at your risk and cost. So you bear the risk and cost. So if he had to work till 21st of May 1997, then I will appoint, and once he abandons, I have to make an alternative arrangement. So I appoint the first contractor, who is an ad hoc contractor in his place, at a much higher rate of 300 plus schedule of rates, because it is a spot tender. Whatever quotations come on the spot, it was taken and the work is given. Thereafter I float another tender 3 months thereafter and appoint a regular contractor at again a higher rate. So by his abandoning the contract before the contract period, I have incurred extra cost expenditure by appointment of another contractor who was appointed at his risk and cost, which is mentioned in the agreement also, that you can't leave the contract midway and then say, if the reason being that
When is the agreement? So basically what is falling for consideration is the agreement?
is the agreement.
Okay, let's see the agreement.
It is Exhibit 16.
I want to see first the termination letter.
Termination.
Where is the termination letter?
The
Exhibit?
termination letter is Exhibit 7.
Exhibit 7. Kindly read the termination letter.
This subject is termination of regular contract.
Just a moment. Okay, please read it.
You were appointed as a regular HT contractor at SSP Surya CWC Hazaribagh for a period of 2 years at 181 ASOR above schedule of rates for handling and transportation work, while this office letter of event dated so and so. Accordingly, you joined on 27/5/1995, and as such, your contractual period was to expire on 26/5/97, but you did not complete your full tenure and resigned midway on 7/8/95. Right from your joining, your performance as handling and transport contractor at SST Surya was not found satisfactory. Besides, you had failed to fulfill your contractual obligations. You had also stopped the work since 4/8/95, for which FCI has sustained heavy losses towards DCWC demerit charges, forfeit charges, extra costs on H&T works, etc. FCI, DMSC, District Manager FCI Hazaribagh has also informed that you have not paid wages to the labourers engaged by you since July 95, which has caused unrest amongst labourers. District Manager FCI Hazaribagh has also requested you to resume work, but you did not turn up. Besides, this office has also issued a notice under reference of event number dated 11/1/96 ordering you to resume HT work within a week. Otherwise, work will be got done at your risk and cost, and contract will be terminated. But you did not respond all these communications. Due to your failure and unworkmanlike performance, FCI has sustained heavy losses towards DC, WC, extra costs on HND works, etc., for which you are responsible, liable to bear the losses as per terms of contract. Under above circumstances and in exercise of powers conferred under Clause 10B and C of the tender agreement, your HNT contract is hereby terminated. Besides the security deposit amount of 30,000 plus earnest money amounting to 20,000 furnished by you are hereby forfeited. Any amount of the tender agreement towards dues and losses suffered incurred by the corporation as a result of your said breach of contract. However, the same will be intimated you separately for arranging payment. Any extra expenditure incurred suffered by the corporation arisen due to risk and cost arrangements for the period for 4/8/95 to 26/5/97 will also be recovered from you. This is without prejudice to other rights and remedies of the corporation under terms of the contract.
So the special damage has only occurred when, due to his abandoning, we had to terminate the contract, appoint another contractor through tender process who comes at a higher rate. We don't know during this period what will be the volume, so it can only be assessed when the period is over, and when the period is over, the assessment of extra expenditure is made and then the suit is filed. Therefore, we are saying that this cannot be the date.
and it is not a case
Under
of
the circumstances and in exercise of power conferred under such and such of the tender agreement, your ST is hereby terminated. The security etc. is forfeited. Okay. When did you make arrangement for alternative?
the alternate arrangement is appointment of the other two contractors.
You see, you have terminated on 13 to 96. The first alternate arrangement is 19-10-95.
1910.
This is
Yes.
prior to termination.
Yes, yes. So that also there is a provision in the contract. This may be appreciated. It is a contract for handling and transportation of food grain. If a contractor has left the food grain even before termination, we can make arrangements for lifting the food grain and supplying. We can't leave it at the rail head. We can't not lift it, and therefore the moment the abandonment comes to the knowledge, some alternate arrangement, and therefore there is the provision for ad hoc contract and then a regular tender.
Was any rate fixed in the contract?
Yes, the rate is 181 ASOR, which is above
At
schedule.
what rate did you retender it?
The retender is both those letters are exhibited documents. First is Exhibit A, which is the ad hoc arrangement. This is to Satyadev Prasad. It is 361%.
What was the earlier one?
First, the awarded rate was 181%. This is 361% spot tender, and then the regular tender is floated by Exhibit 9. In Exhibit 10, it is given to a cooperative.
In a case of risk purchase, at the risk and cost, whenever any risk and cost arrangement is made, do you still give the opportunity to the original tenderer to do the work at the matching cost? Is there any such provision?
No, there is no such.
So you can have risk and cost at any rate you want.
No. Because it is a continuous contract, transportation of food grain is a continuous process. Therefore, in order to prevent disruption of supply of food grain, the contract is for a tenure.
So that's fine. But in a case of risk purchase, risk and cost, right? In a case of risk and cost.
Because he has refused, I have to appoint. Otherwise,
That's
I could
right.
not have appointed.
Okay. If he refuses, you have to appoint. But at the time, once you appoint and at a particular proposed rate, do you still give them an offer to perform?
No, because it is terminated once the contract is terminated, then there can be. Before contract is terminated, if they request, it can be reconsidered. But since after the ad hoc arrangement is made, a regular tender was also floated, and the regular tender also was another cooperative was appointed. So once the second regular tender has happened prior to that completion of that period because of premature termination due to non-performance, then there cannot be any opportunity.
And that is exhibit 11.
And what is the rate under exhibit 11? At what rate did you retender by exhibit 11? And what is the period of this contract?
Tender is exhibit 9, tender notice 2311. The period is 27/11/95 to 29/11/95. This I think is the ad hoc.
You make arrangement in bits and pieces.
So that ad hoc arrangement is the immediate arrangement which has to be made.
This tender
after-
is also for ad hoc arrangement.
No, this is regular. Surya Shramik
This
is exhibit
So
11.
this is also for a very short period,
This
not covering the entire period.
is the point.
27/11 to 29/11.
No, this must be for the balance period. The appointment letter, I'll just check.
For a period of 2 years from the date of joining, right? Is it risk purchase? Risk purchase will be limited to that period.
So till that period only we have.
The 2 years
No,
from
but
35/96.
no, but the demand notice is only till the period.
That's a separate thing.
Yes.
But this is not a risk purchase.
No, this is a risk purchase because
Risk purchase is always for the balance period.
the contract. So the loss will be confined to the period because nobody will come only for 6 months. If the regular tender process is done, ad hoc arrangement is done to meet the immediate crisis because there may be food grain at the railhead, it has to be transported and shifted out. Thereafter, a regular contract has to be floated, and that regular contract can be for any period, but the original contractor who defaulted, his liability will be only till the tenure that he had to perform, and that calculation is given in the demand.
Because you, as per your tender, there is no quantity fixed.
Yes, so that is, I'll show that it mentions that there is no definite volume, it is a
So
tenure contract.
when there is no definite volume, then whatever was lifted for a particular period has been taken by you into calculation.
Correct.
Where is
And
your demand notice?
Demand notice is demand notice is exhibit 14.
Yes. Show me the calculation. Shortage of stock.
This is the total assessment.
Read it. Read the various heads.
Yes.
Shortage of stock.
Shortage of stock. First is towards shortage of stock. This is the amount. Second is towards approval of DC.
DC is what?
Demurrage charges. The time allowed by railways to clear the wagons. Free time. If it is not cleared within free time, then the railways
And towards accrual of WC. What is it?
forfeit charge. The time within which we have to clear the platform once the food grain is offloaded to the
Unpaid wages.
Unpaid wages, because we mentioned in the letters also that he had not paid wages and it resulted in labor unrest also.
Towards unadjusted on account of payment received by you in 3 different. This is regarding some accounting.
Yes.
Okay, extra expenditure towards work got done at your discount cost with effect from 20/10/95 till 26/7/19.
97.
There is no breakup to this.
There is no breakup.
It's huge amount, 24 lakhs.
Yes, there is no breakup, but it can be calculated on the basis of the higher rate.
Then there is another head, value of work done from 1/7/95 to 19/10/95.
Yes. This has been adjusted. The work he
This
has
is done
by the contractor, the defendant, respondent. So that has been also adjusted. And then a demand has been
this demerit charges and these charges are for which period?
for the period he worked, also 5 months.
From where do we get this?
There is no dispute. There is no challenge to the termination. There is nothing in the evidence that they have transported the entire goods. They had made all labor payments. Even though I understand the plaintiff has the burden to prove the case, but these documents were placed on record.
Apart from this, apart from the tender and apart from this, have you adduced any evidence regarding payment to third parties? Have you adduced any evidence regarding payment to third parties?
Payment to those two contractors. Apart from this, there is no other.
Then how do you prove your damages? Then it would be the complete picture, no? How much they have actually lifted, how much did you actually pay them? Because you just have rate. Volume is not there. You have to pay as per the rate. Volume is completely missing. Then how do you prove your case? Even if we overlook the limitation for a moment. The demand notice is sufficient.
The contract condition says that what if there is any
The-
demand, he will accept the demand in case of default. The demand notice will be served by the senior regional manager, which will be treated as final. That is only
Final
a
is
condition in the
But you are seeking recovery, no? You have to prove your case that this was the default, this was the work undertaken, and this was the payment made. Where is that? क्या सुनवाई किया? Damages तो पूरा ही आपको prove करना होगा. Did you exhibit any document regarding payment to railways, regarding demerit charges, wharfage charges?
Those documents are not.
Nothing. Then in absence of those documents, how will your suit survive? Even if, let us assume for a moment that it was not barred by litigation. These are basic documents.
I can only say that it was not disputed or seriously denied also by
Seriously denied किसको बोलते हैं? Admitted?
No, it was not admitted, but at the same time there was no rebuttal evidence to
Rebuttal क्या? This was for you to prove.
that
तो ये
he
5
has-
रुपए दिए हम risk purchase में या risk execution.
No, but we have at least proved that the contractor had to be engaged at a higher rate because of his
Mere
abandoning.
engagement of contractor is not sufficient because it is a rate contract.
So at
You
least the
can
higher rate.
also have a situation that you engage a contractor through tender, but he performs no work. Maybe that you have no food grains to be transported. It's just a rate contract. ऐसा होगा. ये तो वही हो गया. I'll give you an example. Retainer बना लिए लेकिन एक भी केस नहीं. It is as good as that. अब वकील लोग वकील की भाषा समझते हैं, होता है ना ऐसा, रिटेन काउंसिल बना लिए लेकिन पूरा साल एक भी केस नहीं, तो एविडेंस नहीं आ इसमें क्या करेंगे? जजमेंट पढ़ते
If I place the contract first, because we are on the exhibits.
It has been dismissed only on account of limitation.
No, on all issues, merit as well as
Contract.
5 issues were there.
Which article will you be referring to for the purposes of limitation? Let's complete the point of limitation. Which article?
We are referring to section 23.
Section 23 of what?
Limitation Act.
Section 23. This is a limitation act. क्या है section 23?
Special
Limitation.
Ready?
Section 23 suits for compensation for acts not actionable without special damage. In the case of a suit for compensation for an act which does not give rise to a cause of action unless some specific injury actually results therefrom, the time period of limitation shall be computed from the time when the injury results. So we have taken this ground that this is a risk and cost contract. It is also possible that I may have got a subsequent tenderer at a lower rate.
That's it.
Lower than it, and therefore I may not suffer any loss. So by on the date of termination, it is impossible for us to
the liability is yet to crystallize.
yes. So the liability assessment in a case of abandonment of a 10-year contract will depend if any special damages are caused due to appointment of a subsequent contractor at a higher rate covering the period during which the original contractor had to work at a lower rate.
You have no liquidated damages clause, nothing.
That is
Reassessed, it's not there.
That is very meager because the nature of the contract is such we cannot predict, we only give in the contract we mention that you get acquainted with it.
What is the, which clause of the contract do you want to show? Show me the contract.
The contract is exhibit 16. All photocopies were marked exhibit because all original documents were, there is evidence from one of the witnesses that the counsel who was entrusted never returned and abandoned the case. So thereafter on his testimony, at least all the documents of photocopies, office copies, but they have been exhibited.
Any FIR?
FIR,
regarding loss
there is
of
no
documents.
FIR, but in his evidence he stated that they have written a complaint to the
Where?
to the High Court Chief Justice that the original documents were taken by our advocate and not written.
That complaint letter has been exhibited?
No, it is only in the oral evidence, but documents have been exhibited.
बड़ा अच्छा, एक वकील दूसरे को बचाते रहिए और उसके बाद कोर्ट के माथा में डाल दीजिए.
No, I'm only for clarifying that why these are photocopies.
The court has taken objection to that.
No, the court has accepted these photocopies that because it is maintained in the official courts, these are all office copies. And even the defendant defendant objected to production, but defendant is not denying the contract, that there existed any contract.
And these are standard form contracts.
These are standard.
Okay, Exhibit 16, which clause do you want to rely on?
First is C, volume of work. This is at page 48.
48, volume of work.
This is mainly to explain the limitation why it was
according to us not barred by limitation, and it is not the termination date but the completion date which should have been taken as the date. No definite volume of work to be performed can be guaranteed during the pendency of the contract. However, some items of general information are given so and so are intended merely to give
tenders. This is just to show that it is not a particular contract for a particular job or particular work, and therefore assessment of compensation would depend only after completion.
That's right, fair enough. What else?
next is
Where is risk purchase?
that is clause 10. Roman 10.
Roman 10 of?
Roman 10 of the terms and conditions of the same contract.
At page number?
Page number.
I have English 10, but I have not seen Roman
10. Page 58. Internal page is 14, English version.
This is summary termination.
Summary termination. This is the termination. And just above it is the period of the contract also, to show that it is for a two-year period.
That's right.
9 years. It is 2 periods. Then is summary termination. In the event of contractors having been adjudged insolvent or going into liquidation or winding up their business or making arrangements with their creditors or failing to observe any of the provisions of the contract or any terms and conditions governing the contract, the regional manager shall be at liberty to terminate the contract forthwith without prejudice to any other rights and under the contract, and get the work done for the unexpired period of the contract.
That's
at the risk and cost of the contractor, and to claim from the contractors any resultant loss sustained or cost incurred. The senior regional manager shall also have, without prejudice to other rights and remedies, the right in the event of breach by the contractor of any of the terms and conditions of the contract to terminate the contract forthwith and to get the work done for the unexpired period of the contract at the risk and cost of the contractor, and to forfeit the security deposit or any part thereof for the sums or sums due for any damage, loss, claims, expense or cost that may be suffered or incurred by the corporation due to the contractor's negligence or unworkmanlike performance of any services under the contract. Now, clause C is important. The contractor shall be responsible to supply adequate and sufficient labor, scales, trucks, carts, any other transport vehicle for loading, unloading, transport and carrying out any other services under the contract in accordance with the instructions issued by the senior regional manager or an officer acting on his behalf if the contractor fails to supply the requisite number of labor, scales, trucks, so and so, shall at his entire discretion without terminating the contract be at liberty to engage other labor, scales, trucks, carts at the risk and cost of contractor, who shall be liable to make good to the corporation all additional charges, expenses, costs or losses that the corporation may incur or suffer thereby. The contractor shall...
That's right, we have seen that. What else?
Now, there's only one last line, that decision of the senior regional manager shall be final and binding on the contractor. I can only take help of this one line in the contract to say that the demand notice should have been accepted as a
notice is a decision.
Because that demand notice is
demand notice is just a demand notice.
Yes, it is the demand notice under this clause 10 B and C given by the senior regional manager. So this is, it was agreed that if there is an extra expenditure, it will be accepted, and there is nothing in the evidence, contrary evidence to show that there was no non-abandonment. He has not written any letters, although he has made allegations verbal
that he was not allowed to work. They always wanted to favor Satyadev.
Any counterclaim?
No counterclaim. Did not challenge the termination. Nothing. No documents to show that he was prevented or that there was.
The demand notice was served.
Demand notice was served.
By what mode? Have you proved service of demand notice?
That has not come, but it has been exhibited.
Has he admitted service of demand notice?
He is not admitted, but it is exhibited.
No, exhibited means what? Exhibited means nothing. Exhibited means nothing. Either he would admit, because if he does not receive the demand notice, he has no opportunity to respond to that, to dispute it.
But in this suit, in his written statement, it is not his case that he has.
There is a finding that there is no evidence that demand notice was served.
What else? आप impute judgment पढ़े फिर भी आप ऐसे Service of demand notice is absolutely essential to impute anything, any admission on their part. That's all. Anything else?
Only the judgment is there.
Okay, let's read the judgment. So you are primarily relying upon Exhibit 16, which is the contract. Then you are relying upon the termination letter, which is Exhibit number 7. And then you are relying upon the demand notice. Notice Exhibit 14. Then you also rely upon Exhibit 8 and 9. 8, 9 and 10.
8, 9 and 10 appointment.
These are appointment of alternative arrangement.
Alternative contractors after his abandonment.
Alternative arrangements. Termination letter was served.
Termination letter.
Is there any finding regarding termination letter? Finding of termination letter? What was the mode of service of termination letter? That also we exhibited photocopy.
Everything was photocopied because the originals, as it will become clear from evidence of PW1, it was taken and handed over to the conducting advocate who did not return it. And then another.
Who was the conducting advocate at the trial court?
At the trial.
You,
the corporation.
Just a moment. As per law, you are supposed to file copies of the documents at the time of filing of the suit itself.
Correct. So that is why it was given along with the suit. It was formed the basis of the suit.
Yes.
But he did not return it. And he did not conduct
So,
the case.
so those documents must have been filed in the court.
No. The original were handed over along with the plaint for handing over, which he did not file. And then
He did not file along with the suit.
he did not file along with this. And he did not return. I show the evidence of PW.
Anyways, read the improved judgment.
And then it was all exhibited documents were there.
Let us see the issues framed.
Yes, issues is page 29.
Yes, issues.
Three, 4, and 6 are the main issues.
Appointment is not disputed. Appointment is not disputed. What is the name of the respondent?
Arvind Kumar.
Arvind Kumar. Okay.
Arvind Kumar.
This appointment is not disputed. So Roman 3 will not be a point of determination here.
No, this was this relates to the other two ones.
That's right. The finding with respect to Roman 3 is also against him.
Satyadev appointed a contractor. They say that that is the finding that they were not appointed, though their appointment letters are on record.
exhibit said like.
Is there any finding that they were not appointed?
The findings are all mixed, and they say that we have not been able to prove. It has been dismissed in one line saying that the person PWs, they have no personal knowledge. At page 35 I have marked this as there is no personal knowledge and therefore the court has disbelieved everything. Now the corporation only functions through with documents, and if documents are recorded on and have been exhibited and proved personally, that person's presence may or may not be required. He does not become a hearsay witness because he is producing the records of the corporation. He cannot be there all the time. The officers will be transferred from one place to another.
So you just have a look at this. You just have a look at it.
Page 35.
Page number 34.
34.
I find that plaintiffs have not been able to prove by cogent evidence.
Cogent evidence, and it was defendant who had refused to unload the sugar wagon placed at so and so, so and so.
ऐसा so and so मत पढ़िए, please date and time के साथ पढ़िए.
Okay. This is for the demurrage and wharfage only. It's on 17/10/95 at 3 p.m. Plaintiff's Exhibit 8 is the letter of appointment of Satyadev Prasad, and this letter shows that Satyadev Prasad was appointed as ad hoc HNTC for handling and transporting at Railhead Hazaribagh FSD Saraiya and for transporting stocks from FSD Saraiya at the rate of 361% ASOR.
ASOR is what?
Above schedule of rates. So in the contract end there is a
Kindly
schedule.
continue reading.
This plaintiff's document shows that plaintiffs got accomplished work of handling and transporting sugar from the sugar wagon placed at Railhead Hazaribagh on 17/10/95 at 3 p.m. by appointing ad hoc HNTC Satyadev Prasad on 19/10/95. But this document is not an evidence of the fact that Satyadev Prasad was appointed as ad hoc HNTC on account of any unworkmanship of the defendant or on account of refusal by the
So
defendant.
it did not link. It did not indicate that it is risk purchase, or it was arising out of non-performance of the work. It could be an independent contract. This is the finding. Is it referring to non-performance? Is the document referring to non-performance by the defendant?
Let's cross-check with Exhibit 8.
Exhibit 8. Right?
Exhibit 8 was mentioned.
Nothing.
Says ad hoc purely temporary.
Maybe you may have many ad hoc arrangements, but how do you link this
The
particular?
period is also
Maybe,
for the same
even if
overlapping period
It is
during which the
maybe
defendant had to
overlapping.
work.
You see, you may have hundreds of contractors to do one work.
No, but this is the same place.
Maybe it's the same place.
person, and it is mentioning ad hoc.
No.
Only
Ad hoc-
not
no,
mentioning.
no. You see, in all the risk purchases, the original contract is invariably mentioned. That in the original contract there was a contract, he did not perform, and therefore this particular work is being done in the particular manner. How do you link these two? This is the finding of the court. And
Yes.
we will not
We
interfere
are
with the
linking it.
finding unless we are satisfied that this finding is absolutely incorrect. We will not assume it.
It it is for the same period, therefore it can be.
Merely because it is for the same period.
And because it is an ad hoc arrangement.
Maybe even if it is for the ad hoc arrangement, but it is
So the
not
oral
reflected.
evidence may be
In
seen.
fact, the original
Oral evidence can be seen along with the document PW2.
No.
PW2's
Oral
testimony
evidence
we
will
have
not because these are the persons who have given evidence. They have no personal knowledge. Therefore, oral evidence will be of no value. They have not even exhibited any decision of the company that yes, for this step is to be taken. They could have, because there must be a decision preceding this particular arrangement.
Yes.
So a person who does not have any personal knowledge, what is the big idea of looking at his oral evidence? And everything in a company takes place back by back. It is backed by some or the other decision. Even ad hoc arrangements cannot be made without a decision by a competent authority. Even that decision has not been exhibited. आगे पढ़िए, finding पढ़िए. So at least there is no perversity while saying so. You read it, please. Exhibit 8 goes straight away. Read it further. Internal page 13.
Then says Satyadev Prasad on 19/10/95, but this document is not an evidence of the fact that Satyadev Prasad was appointed as ad hoc HNTC on account of any unworkmanship of the defendant or on account of refusal by the defendant to unload and transport sugar from 10 wagons of sugar placed at Railhead Hazaribagh. There is nothing in the appointment letter dated 19/10/95 Exhibit 8 to show that the appointment of ad hoc HNTC was occasioned on account of refusal to perform the contract obligation by the regular HNTC Arvind Kumar Sinha. All the documents proved and exhibited by the plaintiffs show the unilateral declaration of the officials of FCI that the work of regular HNTC Arvind Kumar Sinha was not found satisfactory. On behalf of the plaintiffs, 2 witnesses have been examined to prove the defendant was negligent and was not performing the contractual work properly during the period for which he was appointed as regular HNTC. The witnesses examined are PW1 Manoj Kumar, who at the date of examination was posted as manager at District Office FCI Dhanbad. He has proved documents exhibited on behalf of the plaintiffs, but during cross-examination he has admitted in unequivocal terms that he himself had not participated in the preparation or issuance of any such documents. He also admitted in para 13 that all the letters proved by him were submitted by FCI in connection with this case, but he had not personally seen any original document before proving those documents in the court, as the same were presented before him for the first time. His evidence goes to establish that he himself was not posted either at FSD Saraiya or at District Office Hazaribagh during the period when the defendant was performing the contractual work and during the period when defendant's contractual work was not found satisfactory by the department. Therefore, it appears that this witness has got no personal knowledge of the occurrence or the happening during the period when the defendant was performing his contractual work as regular HNTC at FSD Saraiya or Railhead Hazaribagh. Hence, this witness is not competent to prove that plaintiff suffered any loss or damage on account of unworkmanship or negligence on the part of the defendant. PW2 Chandrasekhar Anand is the district manager posted at District Office FSD Dhanbad, and during his cross-examination he fairly admitted that he has joined the service in the month of January 2012 and came to know about the details of this case through the documents maintained in the office. This statement of this witness goes to show that he too has got no personal knowledge as to what transpired in the year 1995 when the defendant was performing his duty as regular HNTC for handling and transporting at FSD Saraiya Railhead Hazaribagh. So this is how the oral witnesses have been treated.
What is the perversity in this finding?
Now we
says
They
that
had no, they have no
there is
personal
one
knowledge.
essential issue which has not been framed
What is
and
that?
not been discussed, is that which would have been fundamental to deciding this case, because there is at least evidence that he has not completed the tenure, and non-completion of tenure invites penal
there is no
consequences.
liquidated damages.
No, there is, but there should have been an issue whether he abandoned the contract or not.
So,
If they remain silent,
just
they
a
throw
moment. Just a moment.
the. Yes.
If a person abandons the contract, right, then the consequences flow, that risk purchase or whatever has to be carried out, and whatever be the loss incurred by the company is to be reimbursed. Simple. There could be a situation that there is no reimbursement required. Possible?
If it is a lower
If it
rate,
is so. If it is
if
lower
it is
rate.
a lower
So
rate.
therefore mere breach does not translate into damages.
Yes.
So he breach, even if it is proved, you get nothing out of it.
No, so we are saying that there are two issues. One, abandonment under the contract itself provides for some penal consequences if our case is the work is done at the risk and cost and a higher expenditure is incurred. We have brought documents, two
You
documents.
just tell us mere abandonment of contract.
We are only saying, it may be heard for a minute.
You have
The
forfeited
moment-
the securities.
That is
right?
only 20,000.
Whatever be it,
out of 25.
whatever
lakhs.
be it, but you have forfeited the securities. They did not file any counterclaim to get the money which you have
So
adjusted.
therefore, it is admitted at least. Then it should be treated either as admitted or
But what
an issue
admitted?
has,
They-
that he
you
has
have-
abandoned the contract.
You see, they did not. I don't know why did they not. They did not file any counterclaim with respect to the work they have performed. That
They also did not do that.
That's right. So we cannot
Although
have
we
a,
adjusted
so,
that money in the demand.
So therefore, we cannot have a decree in their favor because there is no counterclaim, there is no set off, nothing.
No, my limited submission, if there was an issue which is fundamental to the determination of damages, whether there is abandonment.
You tell us what are the points for determination.
The points for determination is if whether he has abandoned. That issue has not been decided. The court remains silent on it. I understand the burden is on the plaintiff. Plaintiff failed to prove, but on the basis of the plaint alone, it cannot, or on the basis of the WS, that issue, if it is his case of denial, that I have not abandoned the contract, then that is a fundamental issue which should have been framed, whether on facts there has been an abandonment or not.
Let's take it that he abandoned it.
Yes.
What is the
Then
consequence?
we say that we have brought on record two documents, according to us, which specify his rate is 181%, the other rate is 361. So if there is a higher subsequent rate, then even if one bag is transported, I have suffered a loss.
Where is the proof that one bag was also transported?
That is in the demand letter.
Demand notice is not a proof. Please don't.
The
Please
demand
don't substitute.
notice,
No. Demand notice is no proof.
it can be deduced backwards if we,
How is it possible?
on the basis of
Even
difference of
the
rates.
service of demand notice you have not proved. Let us say that even one
Even
bag.
assuming it was not served on him, it was served in the suit.
You forget about it. You have to prove that there was some work done on his account. Where is the proof of that work done?
So that those
आपको
that is-
एग्जाम्पल इतना बढ़िया दिया, रिटेनर बना दिया लेकिन एक भी केस नहीं दिया, तो क्या होगा बताइए?
यहाँ पे एक
आपने अपॉइंटमेंट कर दिया दूसरे का लेकिन काम नहीं कराया, कहाँ
नहीं, लेकिन
कहाँ
अगर
prove
मेरा
किया?
बिल निकल जाएगा यानी पेमेंट का देन तो can
कहाँ है बिल?
There is no bill, but there is a mention in the demand notice that this is the, it would have run into hundreds and
Could have
thousands
put
of
एक और
documents.
2-3 सुन्ना और लगा देते उसमें क्या? 2-3 more zeros. You have not proved your damages at all. Damage is required to be proved. एक भी बिल आप दे देते जो उनको आपने पेमेंट किया, तो और उसके बाद जो आपने जो जिसको आप रिस्क परचेज बोल रहे हैं, alternative arrangement बोल रहे हैं, those documents are not linked to this contract.
I'll only submit that the dates, if taken note, will show.
We will
In
not
fact, the
interpolate
subsequent
this.
tender notice may mention. There is a tender notice also.
It mentions about
After
abandonment
Satyodaya,
of what?
about Suresh Ramik Sayog Samiti.
It
which
mentions
is,
about that.
I
That is
think
Exhibit 10.
It is Exhibit 9. The subsequent one.
No, it doesn't. It doesn't mention. कुछ नहीं है इतना लूजली अपने केस को हैंडल करते हैं फर्स्ट अपील में क्या होगा कोई एडिशनल एविडेंस भी नहीं है और वैसे भी एडिशनल एविडेंस जो आपके पास डॉक्यूमेंट्स है उसको तो हम लोग वैसे भी नहीं एंटरटेन करेंगे सुन लिए अब पढ़िए जजमेंट पढ़िए वी कंक्लूड योर
Last finding is with regard to limitation.
नहीं आप थोड़ा और पढ़िए
हाँ,
इशू वाइज फाइंडिंग पढ़िए इशू नंबर 3 वी हैव सीन राइट this is also decided against
Para 11, no breakup is there.
no breakup is there
Para 11 says that there is no
breakup, nothing.
And DCWC railways I have
कोई
not.
रिसीट नहीं है कोई पेमेंट का डॉक्यूमेंट नहीं है
That I'm not reading it. I'm
yes,
mentioning
I've
what
seen
is
that.
the gist because I've noted in the margin. And then in Para 11 end it says that the extra work expenditure has not been proved. Only the amount is mentioned, claimed as extra expenditure in the last 4 lines.
देखिए आप रिस्क परचेज का कोई डॉक्यूमेंट नहीं लाए आप डेमरेज डिमांड का कोई डॉक्यूमेंट नहीं लाए तो देयर इज नो क्लियर कट कॉज ऑफ एक्शन टू calculate the limitation. This is the finding of the court. The court does not say that the calculation will not begin from the happening of a contingent event. The court says that there is no clear-cut evidence on that. The date of payment of damage, wharfage, the demand notice for that, the risk purchase का कोई भी document linking to this particular contract. Then that contingency that it happened on such and such date is not there at all. So limitation is also likely decided. आपको क्या बोलना है? बताइए.
Judgment passed by the trial court is perfectly legal, Mother. The suit is barred by limitation. There is no document regarding.
आप मेरी बात बोलेंगे कुछ अपनी बात भी बोलेंगे.
But since it is a money suit, they have to prove the negligence. They have to prove the loss also. They have not proved the loss simply by saying that they have engaged as another ad hoc contractor at the higher rate. That will not suffice. They have to prove. So for negligence, they have also not proved my negligence.
कल हम लोग कुछ सुबह 10:30 बजे चला। 10:30 बजे कोई टाइमिंग है? अभी आज से कल कोई गया है 10:30 बजे टाइमिंग? टाइम के साथ देखिए सर, FA number 49 of 2020. Learned counsel for the parties are present. This appeal has been filed against judgment and decree dated 30th of June 2019. Decree signed on 26th of June 2019. Passed by learned civil judge within bracket senior division bracket close Roman 2 Hazaribagh in money suit number 10 of 1999, whereby the suit preferred by the appellant has been dismissed, not only on merits but also on the point of limitation. The learned counsel for the appellant, while challenging the impugned judgment, has submitted that the sole defendant participated in tender process and executed an agreement dated 22/7/1994, which was valid for a period of 2 years, by quoting the rate of 181% above schedule of rate within bracket ASOR. And he was appointed as regular HNTC क्या हुआ?
Handling and transport contract.
Regular handling and transport contractor, white letter dated 22/5/1995/24/5/1995. The defendant joined on 27/5/1995, and therefore his contract was for and therefore his contract started from 27/5/1995, which was scheduled to expire on 26/5/1997. The learned counsel has submitted that there was no fixed quantity as per the contract, and it was a rate contract for handling and transportation of food grains. He submits that suddenly, with effect from 19/10/1995, the a notice was sent to the defendant through registered post by the plaintiff as the defendant suddenly stopped the work. And another notice was also sent on 6/11/1995 by the depot in charge, asking the defendant to pay wages to the labourers. It was a case of the plaintiff that there was a breach of contract, and in spite of notices, the defendant did not perform his work, which led to termination of the contract by letter dated 13/2/1996, with a clear stipulation that the remaining work will be done at the risk and cost of the defendant. the learned counsel has submitted that consequently steps were taken for the purpose of performance of the contract for the remaining period, and initially ad hoc arrangement was made by Exhibit 8. Dated 19/10/1995 and subsequently through tender notice through limited tender notice dated 23/11/1995, and thereafter one Satyadev Prasad was appointed as contractor at the risk and cost of the sole defendant by letter dated 1/12/1995. The appointment letter of Satyadev Prasad is at Exhibit 10. What is Exhibit 11 क्या है?
Exhibit 11 is the appointment letter to Surya Shramik Sahyog Samiti. Another contractor.
Another contract
Ad hoc. He was ad hoc
contractor,
in his regular.
namely Surya Shramik Sahyog Samiti, was appointed while as a regular contractor by letter dated 30/5/1996 within bracket Exhibit 11, which was for a period of 2 years, and the rate was 351% above the scheduled rate. While referring to Exhibit 8, 9 and 10, the learned counsel has submitted that Exhibit 8 was 361% above the scheduled rate. Exhibit 9 was the tender notice. Exhibit 10 was appointment of Satyadev Prasad at 341% above the scheduled rate, and Exhibit 11 was the appointment of Surya Shramik Sahyog Samiti Limited at इसमें परसेंटेज नहीं लिखा है ना, but
It is mentioned in the subject only.
at 351% above the scheduled rate. The learned counsel has submitted that the defendant was appointed at 181% above the scheduled rate, and therefore the remaining work was performed through at the risk and cost of the defendant at much higher rate, and ultimately a demand notice dated कौन सा था लेटर?
Exhibit 14.
Dated 37/1998 within bracket. Sorry?
2/1/1990. Exhibit 14 is 2/1/1990.
2/1/1994. Exhibit 14 dated 2/1/1994 was issued within bracket Exhibit 14 giving the details under different heads with regard to the damages suffered by the plaintiff, which included damages towards shortage of stock, accrual of demerit charges, accrual of warfare charges, unpaid wages to laborer, certain payments made to the defendant, work done at the risk and cost of the defendant for the period from 20/10/95 to 26/7/1997, and also for the period from 1/7/1995 to 19/10/1995. नहीं, ये वाला रहेगा 20/10/1995 to 26/5/1997, and the entitlement of the plaintiff for the work done with effect from 1/7/1995 to 19/10/1995, for which no bill was raised by the plaintiff, was also adjusted, and consequently the demand of rupees 25,67,354.16 was raised. The Learned Counsel has submitted that the records of the case clearly reveal that the defendant was appointed as the contractor and he had abandoned the work, but the trial court did not frame any issue as to whether the defendant had abandoned the contract or not. He has submitted that had the same issue been framed, then under such circumstances, the entitlement of claim of the plaintiff to receive payment on account of work done at the risk and cost of the defendant would naturally flow, and therefore the suit was fit to be decreed. The Learned Counsel has also submitted that so far as the point of limitation is concerned,
There is one more ground in the contract 10C, that one line, the determination of the senior regional manager will be final.
okay, the
Demand
Learned Counsel has also referred to the contract, that is Exhibit
16.
Exhibit 16, and has submitted that as per clause
Roman 10C.
Clause Roman 10 within bracket C of the contract, there is a clear provision that
Decision of senior regional
that the decision of senior regional manager shall be final and binding on the contractors, and therefore the demand notice by itself was binding on the defendant, and consequently the same would have been enough to decree the suit. The Learned Counsel has submitted that clause 10 with bracket C of the contract has not been properly appreciated by the court. Rather, the same clause has not even been referred to by the court, which may be considered in the first appeal. The Learned Counsel has submitted that so far as the point of limitation is concerned, it will be governed by section 23 of the Limitation Act, as it is a case of special damages, and the damages would naturally accrue and computed on the basis of subsequent event of work done by the plaintiff, work which was got done by the plaintiff through third parties, and therefore the period of limitation would not commence from the date of termination of the contract,
Be from the last date of the tenure of his
and it would be from the last date of the tenure of his contract.
tenure of the
And
contract.
considering the last date of tenure of contract, the suit was certainly within the period of limitation. He submits that this aspect of the matter has not been properly considered by the learned court, and therefore the point of limitation has been wrongly decided. That's all.
This one judgment, although it is Bombay High Court 23, there are not many judgments.
Any particular
Very old.
paragraph?
There are two separate judgments written, and it is under the old acts. We'll have to check. It was a case of an acid attack where compensation was claimed.
You tell us which paragraph are you referring to. Which paragraph? Paragraph 5 is against you. Please do not cite judgment which you have not read.
It is separate judgment by Judge Kram J. Judge bench.
It's a division bench. Both the judges have given their separate judgments. Okay. So
He's agreed, but he's given separate reasons.
you see, so far as this section 23 is concerned, the findings are contrary. दोनों का finding उल्टा है. Continuing wrong. दोनों में से कौन सा मानेंगे? नहीं चलेगा ना?
It's otherwise also very old. So I'll leave it at section 23.
Ah, that should be sufficient.
There are not many judgments on section 23.
We'll take care of that. The learned counsel, that's it. The learned counsel appearing on behalf of the respondent, on the other hand, has opposed the prayer and has submitted that the plaintiff was claiming damages which was required to be proved through evidence, which the plaintiff has miserably failed. He has submitted that none of the original documents were exhibited before the court and only photocopies were submitted. But apparently no serious objection was taken in connection with production of photocopy of the documents, correct? लेकिन marking सब में with objection. Marking सब में हम with objection देख रहे हैं. इसको last sentence छोड़ दीजिए. The learned counsel has submitted that learned court has considered the documents as produced by the plaintiff and has recorded a clear finding that neither that Exhibit 8, which relate to appointment of Exhibit 8 could not be related to the decision of getting the work performed at the risk and cost of the defendant. The learned counsel has also submitted that in fact there is no link between the in fact exhibit 8 to 11 do not demonstrate that they were arising out of purchase or out of execution of work at the risk and cost of the defendant. Correct? The learned counsel has also submitted that there was no proof that the demand notice was ever served upon the defendant, and merely because a demand notice is issued, the same cannot be a conclusive proof of the damages. The damages are required to be proved through evidence. Even the demand and payment of wharfage and demurrage to railways has not been proved by the plaintiff. He has also submitted that the plaintiff has only given the rates in the contract as contained in Exhibit 8 to 11, but has not proved the actual volume of work done and the payment made to the concerned person. The learned counsel has submitted that the impugned judgment is a well-reasoned judgment considering every aspect of the matter, and the same does not call for any interference. He has also submitted that so far as the point of limitation is concerned, since the foundational fact in connection with payment of demurrage, wharfage, payment to labourer, payment to the third party at the risk and cost of the defendant were not proved by the plaintiff. Therefore, no cause of action was actually disclosed by the plaintiff after the date of termination of contract, and therefore the learned trial court has rightly taken the date of termination of contract as a trigger point for commencement of limitation and recorded that the cause of action, the last cause of action was the date of termination, that is 13/2/1996, and the suit having been filed on 24/12/1999 was barred by limitation. Post for further dictation on day after. हम बना के ले आएंगे, इसको CAB वगैरह नहीं करना, ठीक है? पानी 10:30 बजे 10:30. ये स्टेटमेंट लीजिए. किसने लिया है डिक्टेशन अभी? सौरभ ज़्यादा नहीं लिखा है, इसको टाइप करके देंगे.
Counsel case cited 15 second April 361 of 2016.
क्या बोले अपीला पढ़िए सूट का जजमेंट सूट का केस ऑफ रेस्पेक्टिव पार्टीज पढ़िए इश्यूज जो फ्रेम में हुआ है वो पढ़िए सबसे पहले सब्सटैंशियल क्वेश्चन
ट्रायल कोर्ट जजमेंट हो रहा
ये सब्सटैंशियल क्वेश्चन
सब्सटेंशियल क्वेश्चन substantial question which is given by the appellant.
बताइए पढ़िए
Substantial question or that the judgment and decree passed by the
ये क्या पढ़ रहे हैं सब्सटैंशियल क्वेश्चन ऑफ लॉ कोर्ट फ्रेम करता है उसको पढ़िए मेमो ऑफ अपील से सब्सटैंशियल क्वेश्चन ऑफ लॉ आप सेकंड अपील बहस करेंगे
Yes,
विदाउट
yes.
रीडिंग सब्सटैंशियल क्वेश्चन ऑफ लॉ
the substantial question of law your lordship framed by the court on your lordship.
कौन सा order
By
पढ़ रहे हैं?
order dated 2/8/2020.
पढ़िए
This appeal will be heard on the following substantial question of law.
आ गए इनके चलिए स्टार्ट फर्स्ट रीड द सब्सटैंशियल क्वेश्चन ऑफ लॉ आप बैठ जाइए
May kindly see order number 9 dated August 2nd August 2020.
आप पढ़िए
First one was whether the learned first appellate court committed perversity as though by the order dated 3/12/2015 in civil appeal number 5 of 2010, it was ordered by the learned first appellate court that the petition under Article 41 Rule 27 CPC shall be decided at the time of pronouncing the judgment, but neither took into consideration whatever which was sought to be introduced as an additional evidence by the appellant defendant, nor rejected the said petition under Article 41 Rule 27 CPC. Second, whether the court below have committed perversity by ordering that Exhibit C is not a valid document. The settlement by Exhibit C has not been made by SDO Chopra, who according to the courts below was the competent authority to settle the land to the landless person. Whether both the courts below have committed perversity by ordering that the demand registered to marked Exhibit A and A by 1 do not contain the reference of Exhibit C, which is the original copy of the Parsha of settlement case number 9 of 94/84. These are the questions of law, substantial questions of law.
Are they related to each other?
Yes.
Are substantial question number 2 and 3 related to question number 1?
Question number 1, actually it has been framed because we wanted to bring on record a favor. So far as the appellant is concerned, appellant is claiming land in question by virtue of the settlement purchase granted by the government of Bihar way back in 84-85. So far as the plaintiff is concerned,
You are the plaintiff?
I am the defendant.
You are the defendant. Defendant is claiming by Pacha.
But
You are the defendant. defendant. Defendant is claiming by Parcha.
Defendant is claiming by virtue of Parcha, and plaintiffs are claiming by virtue of Hukumnama and Jamindari receipts and others. Okay, what we want to bring on record to show that the person through whom they claim that they got Hukumnama, they were not the proprietors. They were not the proprietors, and several submissions we had made before the court below, also in court
No,
in
let
trial
us
court
see.
also.
Let us see. Defendant by claiming by Parcha.
Parcha.
Issued by? Issued by?
Issued by Parcha is already on record. It is
Who has issued it?
issued by circle officer. Circle officer, LRDC. These are the.
That is not a competent person.
No, I will come.
Circle officer.
LRDC.
दोनों एक ही आदमी है.
दोनों दो.
दोनों में से किसने इशू किया?
इसमें सिग्नेचर जो इसमें है अंचल अधिकारी का भी है और अप्रूवल भी है इसमें.
Approval of LRDC. Okay.
इसमें पर्चा जो ऐसे ये सब पर्चा जो इशू होता है इसमें जनरली ये प्रपोजल is started and that proposal is approved.
Under which section this Parcha is issued?
These parchas are issued in revenue circulars.
Under?
There are circulars to that effect that landless persons will be issued parcha.
ये SPT एरिया का है, SPT है.
नहीं ये तो छोटा अंकुट है.
CNT. CNT. Let me understand. Is there any circular governing it? Is there anything on record to show that who was the competent authority? The state is also a party here?
The state is a party.
What was the stand of the state?
They have appeared and though they have filed a written statement, but that was not accepted. But they have in their written statement they had said so, that the parcha was granted. This land was never vested, and it vested in the government.
So we will not look at the written statement which was barred.
Yeah.
We will not look at
agree.
that. So state did not file any written statement.
In law, it will be assumed that if it was not accepted, then it definitely was not filed.
Did not file written statement as it was not accepted. Okay. Did the defendants raise any objection? This you are claiming through Parcha, no?
I am claiming through Parcha. That is one of their prayers.
Parcha was under challenge?
Parcha, they have made a prayer that the state has no authority to issue Parcha or
Parcha with respect to Rayati land?
With respect to their. No,
Rayati
it was never a Rayati land.
They were claiming it to be Rayati land.
They are claiming it.
Right. So they say that state does not have the jurisdiction to issue Parcha
with respect to
the Rayati land, and therefore they challenge the Parcha also. Issues of Parcha was under challenge. That was one of the prayers.
But the question would, Your Lordship, if the Parcha is challenged, so they did not challenge the Parcha before the revenue. Rather, several occasions it was under consideration and it was found valid. And I am in possession also. They have prayed for recovery of possession. Their claim, Your Lordship, is based on a Hukumnama. They say that the next landlord granted Hukumnama. Thereafter, there is Jamindari rent receipts and government rent receipts. These are the nature of pleadings of the plaintiff.
As per the plaint, was there a case that the authority who has issued the Parcha had no jurisdiction to issue?
As such, they have not stated, but they have the Parcha. They said that the state has no authority.
State has no authority because it is their Rayati land. But was there case that the person who has issued that Parcha was otherwise not competent to issue.
That was never specifically pleaded, but it was developed in the argument and
Argument से ये develop नहीं हो सकता ना.
and it was,
Authority of a person
yes,
cannot be developed through argument.
but that is what is their case, and but there is an issue to that effect. Issue to that effect is there.
किसी को हम बोलेंगे उसको jurisdiction नहीं है.
Jurisdiction.
देखिए jurisdiction का दो point. एक point है कि ये जमीन रैयती है तो नहीं दे सकते. My land you cannot give. Correct? This is one thing. The other thing is that even if it is assumed.
There is a difference. Your Lordship may kindly appreciate. This is a Parcha not issued under the Bihar Privileged Person Home Street Act.
That's
in that cases the Parchas are issued for the ready lands. Here the land is
Mr.
a
Sharma,
land of Khas land.
I'm not always speaking against you. I'm just asking you.
Yes.
You are the defendant.
Right.
The plaintiff filed a suit saying that this Parcha the state could not have issued because it is their rayati land.
Their main prayer, Lordship, is for a declaration of their title over the land.
That was the main prayer.
That
is consequential. Okay.
It is a consequential relief. It can be a consequential. The main relief they are praying for is a declaration of title and a recovery of property. And because we are claiming through Parcha, so that is the reason they have also prayed for this. My Lord, if a proprietor has a right, and if he is the proprietor, then only there is a question of granting hukum. My Lord, the document which we want to bring on record, or rather we have already filed before the first appellate, that was a Khaiwa, that will go to show that who were the proprietors. They are claiming through Surya Narayan Singhs and Tara Mani Singhs and etc. They were not the proprietors. Rather, it was the land of Mishras. So that was a very valid document so far as the defendants were concerned. And my Lord, they have to rather it was their duty to bring those things on record and to establish that yes, he was the proprietor and he has granted it.
You see, we will not look into the as to whether this additional evidence was fit to be allowed or not fit to be allowed ultimately. We will look into the fact that the appellate court has not considered it.
Not at all. No, though there was a order to that effect that it will be taken into consideration.
That's right.
But
there is a clear order, but it has not been ultimately disposed of by that interlocutory application.
By finally disposing of the appeal, rather dismissing the appeal, there was no consideration to that effect.
And according to you, it has a bearing in the matter.
Yes, it has a
because the very basis of the hukumnama, it has the bearing on the very basis of the hukumnama claimed by the.
And we have specifically pleaded that these hukumnama and the receipts, etc., are not disposed, and it will appear from those documents also.
No, we are not on that. We are on substantial.
Yes.
No, we are not on forgery. Now, just tell us, in order to, let us assume for a moment that on account of non-consideration of additional evidence, the matter is to be remanded.
Yeah.
Then, under such circumstances, is it required to decide the other substantial question of that is competent of SDO to issue Parcha?
If the remand is being made, but it is advisable in my human submissions that those questions may be kept in abeyance.
Kept in abeyance? And the second appeal
till a decision on this issue.
Till the second appeal will remain pending?
No. Till the decision on this issue that whether hukumnama or whatever the favor which we want to bring on record, whether they are having any right on the basis of their documents. After all, it is their.
So therefore, issue number 2. Issue number 3, I can make out that it is to some extent relatable to your additional evidence, right? whether both the courts below committed perversity by holding that the demand registered 2 marked Exhibit A and A by 1 do not contain the reference of Exhibit C.
No, my lord, if your lordship will find, just have a look. Your lordship will find there is a reference, already there is a reference. We are having a certified copy. The courts have also been got. So that is an apparent error on the face of it.
Okay, there is a reference to Exhibit C.
Exhibit A by 1.
No, Exhibit A and A by 1, there is a reference of Exhibit C.
A is the rent receipt.
Okay.
So
that will not happen.
Area is there.
What
But
about
so
A
far
by
as
1?
the Exhibit C is concerned, madam.
No. You see, perversity by holding that the demand registered 2 marked Exhibit A and A by 1 do not contain reference of Exhibit C. The register 2, does it contain reference of Exhibit C?
Yes, that's what I am saying. Exhibit C is the Parcha. Your lordship may
पर्चा में रजिस्टर 2 का रेफरेंस नहीं चाहिए. रजिस्टर 2 में पर्चा का रेफरेंस चाहिए.
हाँ हो जाएगा.
Register 2 is exhibit what?
Register 2 का जो
Register 2 is exhibit what?
Exhibit A by 1.
Exhibit A by 1. Okay.
इसमें सेटलमेंट का भी रेफरेंस है और एरिया का भी रेफरेंस है.
इसमें एग्जिबिट सी का रेफरेंस है.
एग्जिबिट सी का भी रेफरेंस है. एग्जिबिट सी भले नहीं लिखा हो लेकिन सेटलमेंट केस लिख रहे हैं.
सेटलमेंट केस का क्या नंबर है?
9/8485. एरिया भी बता दो.
8480. ठीक है. तो आपका ये so far as 3 is concerned, it is open and shut. There is a reference. They have committed some perversity by not referring on the face of it. What about question of law number 2?
Question of law, so far as this question of law is concerned, for decreeing this suit, for a degree of the suit, well, it is well settled principle that it is the plaintiff has to stand on his own. For a moment, your lordship may kindly, for argument's sake, I am saying, if I say that the parcha is even if is not issued by the SDU, not approved by SDU, even then, it bears signature of circuit officer, it bears signature of LRDC, and at several points, your lordship, some power is also delegated. Whether at that point of time it was delegated, he was the proper authority or not authority. These are the questions. But even if assume,
let us see the plate.
But just let me conclude. Even if we assume that this parcha, your lordship, is not issued by SDU, even in that case, he can be only when he can establish that he has a valid right by virtue of hukumnama.
Dad specifically sought a declaration that the circle officer had no right to settle. There is a clear cut.
With respect to parcha, they have, but there is an approval of LRDC. From their parcha, you will see.
So you just tell us under which provision of law this parcha has been issued. Is there any exhibit? Tell us.
Exhibit C. Parcha.
Exhibit C is the only document with regard to issuance of parcha.
That is the only one. But Parcha bears details.
No, that is another thing. Jurisdiction of the circle officer to issue Parcha.
Circle officer signature is also there. Anchal Director signature is also there. And there is also approval also. Though the written statement has not been accepted, but in the written statement they have said that there was an approval also.
पहले A दिखाइए एग्जिबिट A/1 बोल रहे थे ना
A/1 we will copy of the register. मिडिल क्वेश्चन में देखा जाएगा वाइड सेटलमेंट केस नंबर 9 of 8485 लास्ट कॉर्नर में देखा जाएगा तो एरिया 452.1.5 तो कौन सा रेंट रिसीट्स इशू हुआ है ये सब भी इसका डिटेल्स में दिया हुआ
452.1.5 यहाँ पे आगे क्या लिखा हुआ है बाइट यही 452 ही है
जी
452 ही है
हाँ 452 1.51 एरिया
तो कहाँ केस नंबर कहाँ लिखा है
जी
केस नंबर
मिडिल में वाइड सेटलमेंट केस नंबर 9 of 8485
वाइड सेटलमेंट केस नंबर कहाँ लिखा है
ये मिडिल क्वेश्चन में देखा गया
अच्छा अच्छा This is exhibit C, correct? और exhibit C दिखाइए
एग्जीक्यूट सी देखा जाएगा ऊपर में 98485 बंदोबस्ती केस नंबर लिखा हुआ है डिटेल्स ऑफ सर्वे प्लॉट्स वगैरह दिया हुआ है खाता नंबर दिया हुआ है
So property दिखाइए
452 देखा जाएगा तो 1.51 बी जिसमें इसमें नीचे इसमें देखा जाएगा अंचल अधिकारी 14 अंचल निरीक्षक और मिडिल पोर्शन में अप्रूवल भी है ऑफिसर
ये अंचल ऑरिजिनल अधिकारी का साइन है
हाँ है
और इसका LRDC का साइन
LRTC का बीच वाला
ये
बीच
ये जो अंचल निरीक्षक है
थर्ड कॉलम
अंचल निरीक्षक
हमारे पास तो थोड़ा
अंचल
हमारे पास
अधिकारी
फ्रंट कॉपी है इसमें
बताइए जरा इसमें से कौन सा दिखाइए उनको दिखाइए जरा कौन सा इसमें से
यहाँ पर भूमि सुधार उपसमाहर्ता है इस वर्ष भूमि सुधार उपसमाहर्ता में लिखा हुआ है उसको फॉर्म मार के
From where do we get that SDO is the only authority to issue Parcha?
that too from the revenue circulars
ये क्या है ये
भूमि सुधार उपसमाहर्ता है
अच्छा
उसी को LRTC लैंड रिफॉर्म ड्यूटी कलेक्टर अप्रूवल तो है उनका। उस वक्त ये इनको पावर डेलीगेशन था कि नहीं था दीज आर इश्यूज कैन बी बच्चा इनका कोई अभी तक में कैंसिल नहीं रेंट रिसीट्स वगैरह भी हम पेमेंट करते हैं आज की तारीख में
दोनों कोर्ट का क्या फाइंडिंग है इसमें पढ़ी
दोनों कोर्ट का एक ही फाइंडिंग
पढ़ी
सेम कंकरेंट है और एक ही एक
इशू नंबर 3 पढ़िए इशू नंबर 3 ट्रायल कोर्ट पहले पढ़ते हैं इंटरनल पेज 14
रनिंग पेज अब ट्राई
सर
so issue number 3 शायद लिमिटेशन पैरा 3 पैरा
पार्ट में
पढ़िए जरा
इशू नंबर
पढ़िए
whether the land issue was vested in the state by operation of law that is
इशू नंबर 4 ना
हाँ इशू नंबर
sorry for
तो ये तो कोई स्पेसिफिक इशू तो बना ही नहीं है Is there any specific issue whether he had the jurisdiction to issue Parcha? Is there any issue framed?
issue 6 है whether the state official or officials have the right to settle issue
ये तो जनरल इशू है भाई रैयती लैंड है तो नहीं होगा सेटलमेंट का राइट
नहीं रैयती लैंड तो नहीं
रैयती लैंड है तो नहीं होगा लेकिन ये जो जुरिस्डिक्शन ऑफ अथॉरिटी कि एसडीओ से नहीं इशू हुआ है एंड देयरफॉर इट इज इनवैलिड ऐसा तो कहाँ कोई इशू है
ये फाइंडिंग में इन्होंने लिया इश्यूज नहीं है लेकिन स्टेट ऑफिशियल्स का इनका कहना है कि इट इज आल्सो वन ऑफ द फाइंडिंग में है
चलिए पढ़िए जरा फाइंडिंग
इशू नंबर 6
इशू नंबर 6
issue number 6 is at page 30 it has already been found and ruled that the state has recognized settlement of disputed land in court of plaintiff and accordingly Jamabandi has been opened in state record and state has realized it from plaintiff. So without cancelling the Jamabandi running in favor of the plaintiff, there is no occasion for the state official to issue settlement purchase. To the defendant through the said purchase has not been issued by the competent authority, that is SDO, or any order passed by the state officials with regard to settlement of disputed land in favor of the end has been produced. Therefore, I find and hold that the state officials have no occasion to issue the settlement pasture in favor of the creditors. It's sort of a vague finding. As because the learned trial court has come to a finding that their hukumnama, they are having rights by virtue of hukumnama, and has
The finding is that there was already a running Jamabandi
there was
in
a
the
running
name of the.
Jamabandi and
There was already a running Jamabandi in the name of the plaintiff, so there was no occasion to create a parcha.
issue.
That is the finding.
That was the.
And incidentally, the court has gone into the issue that it is SDO Chatra only who is the competent authority.
SDO Chatra, such parchas are to be approved. That what is the opinion of the court?
Is the?
That has to be approved by SDO.
नहीं आप कहाँ से बोल रहे हैं? कोई सर्कुलर दिखाइए, कुछ दिखाइए, हमको तो नहीं समझ आता है. कल को कोई बोलेगा डीसी पर्चा इशू कर सकते हैं. ऐसा इशू ही नहीं. You did not join issue on this. कि whether SDO is the only competent authority to issue parcha, and as to whether the circle officer could have issued parcha or whether the LRDC could have issued parcha, ऐसा तो कोई issue ही नहीं frame हुआ.
An issue frame नहीं हुआ.
तो फिर ये substantial question of law कैसे बना?
State officials के बारे में इन्होंने ऐसा लिखा. ऐसा इन्होंने.
देखिए इतना इस तरह से चीजों को नहीं डिसाइड कर सकते हैं सेकंड अपील में. कल को होल्ड कर देंगे.
वो हम दिखाएंगे.
क्या दिखाएंगे? हम तो सुन ही रहे हैं आपको. दिखाइए. ये जो आप सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम किए, ये कोई स्पेसिफिक इशू ना ट्रायल कोर्ट में बना है. आई एम श्योर एपीलेट कोर्ट में भी नहीं बना होगा.
इश्यूज नहीं बना है, बट फाइंडिंग टू दैट.
इशू नहीं बना है और फाइंडिंग टू दैट इफेक्ट इसका क्या मतलब?
स्टेट ऑफिशियल्स में एसडीओ भी आते हैं.
Sorry?
SDO भी state office.
Right? There is a hierarchy. Yes. There is circle officer. There is LRDC. Yes. There is collector. Yes. Right? There is deputy commissioner. Yes. Right? There is SDO. Various authorities हैं. ठीक है. तो अगर ये डिसाइड करना है कि SDO को पावर था कि नहीं था, या सर्कल ऑफिसर को पावर था कि नहीं था, तो उसका स्पेसिफिक इशू तो फ्रेम होना चाहिए ना.
ये स्पेसिफिक इशू फ्रेम.
तो नई इशू है तो ये सब्सटेंशियल क्वेश्चन ऑफ लॉ में कैसे आ जाएगा? बिकॉज अगर मान लीजिए कोई ऐसा इशू फ्रेम होता है, then under such circumstances the parties would have the opportunity to lead evidence कि भाई ये सर्कुलर है, ये डेलीगेशन है, ये प्रोविजन ऑफ लॉ है. तो ये चीजें हम लोग ऐसे एयर में कैसे डिसाइड करेंगे?
नहीं, लेकिन चूंकि इशू नंबर 6 है और 6 पर इन्होंने कहा है कि स्टेट ऑफिशियल्स को पावर नहीं.
ये जो स्टेट ऑफिशियल को पावर नहीं है, ये इसीलिए ना क्योंकि प्लेंटिफ वाज क्लेमिंग दैट इट इज देयर रैयती लैंड.
नहीं, it is not. It is.
अरे भाई it is not, but they were claiming that it is a rayati land.
Rights.
Yes, they were claiming that it's one thing to say that they have rayati right over the property, and it is another thing to say that SDO does not have the power to issue parcha.
There actually relief was.
And if the SDO does not have the power to issue parcha, then the state will file a suit for recovery of the land, if it is not a rayati land.
But not make any issues. Actually, the relief they have read for that it is the circle officer who had issued the parcha is not valid. But as because there was finding by two courts that the parcha is not approved by SDO, that is one of the major reasons that is against us, and we are claiming through the parcha. That was the occasion for framing such substantial question.
Substantial question of law has not been framed as to whether the parcha issued by whosoever officer is wholly without jurisdiction. That is not the substantial question of law. अब देखिए क्या है आपका ये. भाई सेकेंड अपील में ऐसे होल्ड कर देना कि एसडीओ को पावर था या सर्कल ऑफिसर को नहीं था, you know, it has lot of ramification for the entire area.
What is the substantial question of law? Allow me to read it. Whether both the courts have committed perversity by holding that the Exhibit C is not a valid one, as the settlement by Exhibit C has not been made by SDO Chatra, who according to the court, the court below is of.
So therefore, since no specific issue was framed with regard to the competence of the authority, therefore the court below could not have gone into this point.
But there are revenue circulars that I am
वो तो
also
आप
aware.
देखिए,
I will
आपका
define-
रेवेन्यू सर्कुलर आप पॉकेट में रखिए, उसके बारे में हम कुछ नहीं बोल सकते, बिकॉज रेवेन्यू सर्कुलर इज रिक्वायर्ड टू बी प्रूव. ये कोई ऐसा चीज नहीं है कि स्टैट्यूट हम देख के डिसाइड करें.
सर्कुलर तो रखा है.
सर्कुलर अभी भी नोट कर सर्कुलर कैसे देखें,
After all,
बिना किसी प्लीडिंग के,
अच्छा,
बिना
है
किसी बिना कुछ के आप कोई सर्कुलर
अगर इसको अगर वैलिड हम तो कह रहे हैं कि जो मेरा पर्चा वैलिड इसलिए वैलिड है क्योंकि इसमें एसडीओ की जरूरत नहीं है.
हम कुछ और कह रहे हैं. हम ये कह रहे हैं कि देयर वाज नो ओकेजन फॉर द कोर्ट टू गो इनटू दिस इशू.
I because but the court has both the courts have gone into the issue.
There-
And there is a
therefore,
finding.
therefore there is a question of law regarding perversity on that.
Yes, that's what I am saying. That's what I am saying. That very finding of the court below is not.
So substantial question number 3 is absolutely open and shut. 3 number तो ऐसे open and shut. So far as 2 is concerned, we have to see whether they have rightly gone into this issue or not.
Perversity तो है, perversity के
Perversity तो है.
Perversity तो है.
And so far as 1 is concerned, it's a matter of demand.
It is a matter. So that what I was saying. That it is the
अभी
plaintiff
थोड़ा
who
सा
has to
ब्रेक
establish
चाहिए.
his case.
लंच
Yes.
टाइम हुआ है. आप सोच के आएंगे क्या बोलना है आपको तीनों में. हम जानना चाहते हैं आपसे कि ये जो परवर्सिटी बोल दिया है, ये जो बोल दिया है कि एग्जिबिट सी को सर्कल ऑफिसर या इनको जुरिसडिक्शन नहीं था या सिर्फ एसडीओ को ही था, तो क्या ऐसा कोई इशू आपने ज्वाइन किया था आपस में कि भाई इसको एसडीओ को पावर था कि किसको पावर था?
एसडीओ को पावर था, ये तो हम लाए
किसमें लाए? जजमेंट में कहानी मत सुनाइए आप हमको. जजमेंट का कहानी मत सुनाइए, आप हमको प्लेन से कहानी सुनाइए कि भाई ये सर्कल ऑफिसर को पावर नहीं था, ये फलना आदमी को पावर है ना. ऐसा कुछ तो होना चाहिए ना आपके प्लेट में कि सर्कल ऑफिसर हैड नो जुरिसडिक्शन. ऐसा देखिए, 2 चीजें, एक तो ये है कि रैयती लैंड में सेटलमेंट नहीं हो सकता है. दिस इज वन पॉइंट. दूसरा पॉइंट ये है कि अगर हो भी सकता है तो भी एसडीओ के बिना ये सेटलमेंट नहीं हो सकता. ठीक है, एज पर सर्कुलर और व्हाटएवर. तो सेकंड पॉइंट आपने लिया है क्या? आपका आप प्लेंटिफ है, आप प्लेंटिफ है. प्लेंटिफ का ये केस था क्या कि जो सर्कल ऑफिसर ने जो इशू कर दिया है, अगर मान लीजिए हम लोग मान भी लेते हैं कि ये सरकारी जमीन है या जो भी कुछ है, एज्यूमिंग, then also the circle officer did not have the power to issue पर्चा. क्या ऐसा कोई आपने प्ली लिया है? कोई इशू नहीं बना है, इशू नहीं बना है on the competence of the authority to issue पर्चा. It requires a framing of a separate issue. ऐसा कोई इशू नहीं बना है. ऐसे पासिंग रेफरेंस दे देने कि एसडीओ के अलावा है, तो ये तो आपने जनरल नॉलेज से फाइंडिंग दे दिया है कि एसडीओ क्या मटेरियल है कि एसडीओ ही इस पर्चा को इशू कर सकता है. कॉमन नॉलेज से नहीं चलता ना, लॉ तो फिर लॉ से चलता है. दिखाइए प्रोविजन ऑफ लॉ. है ना. सेकेंड हाफ में हम लोग कुछ रखे हैं ना, 12 बजे रखे थे. किसका मैटर था? आपका मैटर. आपके सीनियर कौन है? ये कंटिन्यू करने के बाद इसको और एक कोई मैटर रखें. एक
और
ही मैटर.
one request for Procedural 31.
कैसे
कल के लिए इसको
नहीं सुनेंगे इसको आप. ऐसे कल के लिए आधा काम छोड़ दो. 25 हम लोग फॉलो अप कर दिए हैं. आप है ना यहाँ पर, आपके कोर्ट के ह्यूमन राइट का आपको चिंता नहीं रहता है. ऐसा नहीं हो सकता. ऐसा मैं मेंशन करके जो है ना इस तरह के केसेस नहीं एंजॉय करना. आपको घर जाना है, हाँ, बस रहिए.